So you can watch it before you actually have to do anything.
Well, and actually, the applicant's not even involved in this discussion, so, yeah, that would seem to be reasonable.
But isn't that what Dolores was saying didn't work? That to invite them to one or two of those sessions isn't fair, so maybe, isn't enough. So perhaps we should allow them to attend the full year, right? I mean, we're starting in January, right?
Yeah, as many as they can. I mean, because, I mean, some of us come back from the experience of actually doing the evaluations ourselves. And so we have some experience, and then there are people in the committee who didn't do actual evaluations, but have been on the committee to do appeals. And now we've got new people who are, again, learning fresh, so yeah.
So it's almost a shadowing with the two members
I think
in the
that's a
coming
good
year.
idea, yeah.
Okay, I think that's a great idea. And that addresses your issues, right, Dolores?
Yeah, I think that if there is a committee member that really has an interest and wants to do that, as long as that doesn't interfere with the rules that are written, that the evaluation, the review will be conducted by, I mean, it's written down who participates in that, but it doesn't talk about observers or shadowing, so.
And David and Tara, is there anything in the rules or procedures right now that would prevent us from being able to do that?
I don't think anything would prevent members from observing and not participating.
Okay, great.
I also think it's a really good idea.
They are allowed to participate. I think that would be good if they're observing, but perhaps even participate in the discussion at the end.
Well, I think the procedures outline that only 2 panel members will be
Okay.
assigned for the review, so that was
Yeah.
the only concern there.
So,
Well,
Well,
we have
I
to
mean-
change the rules then, correct?
We are actually bringing the procedures today,
Okay.
so that's something we could adjust if we want to say at least 2. So that's within your purview.
David, what about the whole qualification to see some of these things? When we initially were involved in the committee, we had to get some kind of Attorney General pass to be able to see some of the documents we were seeing. Did that get dropped, or is that still there?
Are you referring to the criminal history from the DOJ?
It might have been. I just remember I had to do something special, give special fingerprints in order to be able to see these things. That was 4 or 5 years ago.
Yep, we would have to make sure we're in compliance with that rule. We'll have to look at it. I know there is an issue there, but I don't know exactly what the rule is.
All the CBE members have to be cleared for Corey access. That may be what you're thinking of.
So they're already cleared, Caroline?
It's part of the orientation for new members, and I think that's being taken care of by staff, yeah.
Great.
Yes, our members have been fingerprinted.
Bethany?
I just want to confirm, we've been discussing just our moral character appeals, not the initial interview, right?
Right.
Okay.
Our appeals that are on the recorded and written record.
Okay. And so I was wondering, because I know that most of us, like Jim just mentioned, we used to do the actual interviews, and so that's our frame of reference. And so I'm wondering if the new members might have the opportunity to be able to sit in on an actual moral character interview at least once, if they want to, just to see what that process is like, because I think that's super instructive in terms of evaluating an appeal of the proceeding.
I might ask OGC to weigh in on that, because I know when we made the switch over, the agenda item where we bring the staff decisions after the informal conferences, we had to make it very limited because you all serve as the appellate body for someone that might be denied. So that would be my only concern.
Yeah, I would just say that whoever was observing at the staff stage would have to recuse from any participation in the panel at the appeal. I'm using air quotes. I don't know if you can see me at the appeal stage.
Well, and the appeal stage includes both the 2-member
Right.
appeal panel and then also the full committee's ratification of their.
That's right. So they wouldn't, right. And one of the important things is that, all the decision makers have access to the same information, and one decision maker doesn't have access to information, the others don't. So that's why they'd have to recuse, to make sure that the person had an equal shot at the appeal and at the at both stages of the appeal.
Alternatively, perhaps they could observe the conference but not observe the deliberations.
So that's, the only advantage there is they get to see the person as opposed to just hear their voice, right? Is that really worth the effort? Bethany, what do you think?
I do. I feel like from a practical standpoint, someone conducting an appeal of a proceeding should know what the actual proceeding, what happens at that. And I think that for people that are going to come on, the new members and the ones in the future, if they've never actually seen what one of the conferences is like, they don't have the reference point to evaluate it appropriately. I think that that's just the standard, like in the legal world, like ideally we want our appellate judges to have looked at a trial before. And so, I don't know, I just think it's important, but if it's going to create logistical issues or, privacy concerns, that's fine.
Okay, well, I guess if
they're-
they want to avail themselves of that.
If they're all recorded, I might just suggest you could do one that's been finally adjudicated, so one that the CBE is not going to be considering in the future, and then just have them review the recordings. I mean, that could be an option.
But the thing is, the recordings are audio only, so we're missing all the visual
Oh, okay,
cues
that's the
about,
concern. I see.
veracity, yeah.
Okay.
I mean, that's been my complaint about the fact that we're only looking at or listening to audio recordings. I think we're missing a lot of information, but that's another story for another day, I guess.
That is one thing that we do have our program analysts for moral character looking at right now, is we just want to ensure that the bandwidth, if we're recording video through Zoom, is not going to significantly impact it, but we are looking at that right now.
Okay, that's great. Alex?
Yeah, so moral character, I think everyone would agree, is a highly specialized area. As much as it is important to rotate members in and out of that subcommittee, it is equally important, if not more important, to maintain consistency in our decision-making. And so a new member may not have the necessary expertise to make an informed decision that is consistent with prior decisions for similarly situated applicants. And so, and of course, deferring to a fellow, more experienced member isn't really the kind of due process that is contemplated by the rules. And so we have to have some rules in place to ensure new members have the necessary training before participating in formal appellate review. And that's just my opinion.
And do these measures we've been talking about address that at least to some degree?
Yeah, I think it's still very arbitrary as far as how many. I don't think we have a number set in mind, and so we really need to come up with a predictable, maybe a formal rule making, so that we ensure, a new member has to participate in X number of observations, or participate or observe in an X, Y amount of reviews. So some numbers have to be in place. Otherwise, right now, no one knows exactly what rules to go by to ensure that member has the necessary training.
So would it be sufficient to incorporate it in the policy that we're going to be talking about later?
Agreed.
Okay.
Paul, in days gone by, before the changes, the moral character committee had 3 members on each review. And so as a new member, I got my stripes by being one of the 3. And because I was one of 3 rather than one of 2 decision makers, I could hold back, learn, soak it in, and not be the scale tipper to say 2 for and 1 against, or so that helped. Having 3 members in that situation helped a great deal. So I was sorry to see it moved to a 2-member panel.
Okay. Can I suggest we put a pin in this? Because this discussion really now is clearly related to that item that's going to come on the agenda later.
Can I just make a real quick point about that? And, David Lane might hate me for this, but You know, when I served, I really thought it was important that the attorney that was there had historical context as well. And, because they would have been able to say, well, yeah, I remember there was a case, there was a case that was similar, and perhaps, that what you're recommending is going a little too far. But I always think it's important for whichever attorney is assigned to that particular committee stays there for a little while, maybe 2 years or so, rather than switch out. And I don't know what your switch out time is, but that ensures that historical context that Alex was talking about.
Okay, Larry, and then we're going to postpone the rest of this until we deal with the actual
Yeah, I
item.
have a little bit of, again, a contrarian view on this. I served on moral character, and it's a very difficult function of this committee in terms of requires a kind of level of nuance, it's not cut and dry. It's not like you got X number of points on the bar exam, you passed or you failed. To me, the most important characteristic of somebody in moral character process, empathy. You're dealing with people, their lives, their problems, empathy is really important, really understanding what's going on. Not that you're going to, give them a break all the time, but you really got to, it's so different from a lot of the other stuff that we deal with, and in many ways it's difficult for groups like this to really do a good job in that area, because it requires kind of a level of awareness and introspection and understanding that you don't often find in institutional agencies like the bar. So it's just, a challenge.
And some would say that as outsiders to the bar and its culture, appointed by outsiders, that we're the very people that would bring that to the table. And so it argues against leaving that decision with the staff. But let's put a pin in this, because we have a vehicle where we can maybe do something that's coming up later and move on. So I got less so for ed standards, but use committee members on moral character appeals. Next, let's see. Okay, we've already covered this. The testing accommodations between meetings are heard by the exam subcommittee until the amended rules take them out of that loop. For subcommittee chairs and vice chairs, what are we expecting of them? I think I suggest that in many ways they're the full committee's eyes and ears in the process of preparing the staff reports that come to us. Not so much about what the recommendation is, but about looking for things like, have we been given all the information we need to make a decision? I can fall into this habit myself. I assume everyone knows everything I have in my head. And if I write a staff report and don't provide all the relevant parts of that, don't put those on the paper, the people I'm asking to make a decision are, they're not as fully informed as I am. So looking out for those kinds of things. Does the staff report make sense? Is the staff forgetting, something else we've talked about recently or we've done in the past that's inconsistent with just vetting the thing so that it's perhaps a better product and will help us make a better decision. And I mean, I know I did that with Natalie. She will either say just enough, probably not enough, more likely too much. She got plenty of feedback from me when I was chair of Ed Standards. And I don't expect everyone to do that, but I think the more you can add value to the staff product, maybe reduce the time we need to spend here on something. So that's one, I guess that's the main role there. Does anyone think I'm on the wrong track with that? Okay. Then this is a minor point, but we've fallen into the habit of having the subcommittee chairs present items at our meetings. And I don't know where that came from. I don't think it's a bad idea, but I also don't think we need to expect all our chairs to be feel they are obligated to do that if they don't want to. I mean, staff can present their reports. So do you think it's fair to say that's an option for you, current and future subcommittee chairs? Or do we really want to make that an expectation of them? Again, I see no reason to, but
I think it's an option. I think they can work out with their staff person and work out what's best for the two of them, or the three of them.
okay.
Yeah, I was going to say, I mean, I've served on all the committees and the staff have been great about giving the option, at least to me, and I think that probably still
But
is
you,
the same. So
but
I
you
didn't
should be
feel
able to choose
obligated.
not to as well.
Yeah, and they've
okay.
given me that option too, so.
Okay. And then, let's see. The next thing we do, and I mentioned it before, but there are times where members of this committee are appointed to other bodies. The best example, current example, is the Blue Ribbon Commission on the future of the bar exam. We'll be talking about them later too. Past examples, provisionally licensed lawyer working group, that was Dolores and myself. The CAPA analysis group, I know Robbie was on that. I'm not sure if anyone else was. And then the chair, by tradition, the chair of the Ed Standards Committee serves as our liaison to the CS bars. So I wanted to seek clarification and, that our expectation of those people is that they are not just representing themselves and their own interests, but they're representing our interests and the opinion of the group as a whole. And therefore, they need, as part of their service on those committees, to check back with us regularly when they need to gather a sense of what our direction would be to them for what they should be saying to those groups on our behalf. Does anyone, any comments or disagreements with that point of view?
Paul, when you say regularly, is that like at like, I won't say every month, but is it like only at the committee meetings?
Yeah, because of Bagley Keene, we really can't talk in between. We can't come to a consensus, certainly. And sometimes maybe it's not every meeting. It's just as, if the group goes silent for a while, we don't need to hear from them. Okay, no disagreement there. And then another role that's kind of similar is lately staff has been seeking a couple volunteers as they're working on rule proposals to come with us. And I think that's another case where it's really not about you as that representative coming to a particular or influencing the staff proposal to be in a particular way, except that it be understandable, that it hold together, that all the information we need is provided, so that we can make the best decision possible. In fact, I inserted myself into some of those for the last meeting because I knew that I am a especially prolific rewriter of legislation rules, having done that for so many years, that I didn't want to come to the meeting and say, this needs work, because I knew that staff was in a hurry to get things pushed forward. So in addition to the two-person groups that were working with staff on those, I got copies of the rules and I provided feedback, especially on the TA appeals. Did a lot on that. But again, the impetus for that previous expectation that we have one meeting to learn about something, time to think, and then we act at the next meeting, that gives people like me time to have second thoughts, to not have to insert myself like I did, and provide feedback to staff so we can make the rules as good as I think I'm able to. No ego involved here, of course. And others, I think, may feel the same way. So does anybody disagree that the job of these people who are helping staff vet proposals is to not to influence them, but to make sure that they're ready for us to consider?
Paul, I've served on volunteered for a couple of these groups over the past year. And and I think it's important for the new members to know, staff is going to work around your schedule. Secondly, when you work with them, they are thoroughly prepared. And so you're ready to, they'll send you something, you review it, you're ready to go in and provide, your position if you don't agree with them, or if you need some more discussion with respect to the topic itself. A lot of them are open, and I think that just about every group that I participated in, everybody's had the opportunity to engage in a robust conversation in an amicable fashion and ultimately achieve a just result. So I think that's something that our new members should know, that what to expect if they do a volunteer for something.
I'm not sure you're agreeing with my proposal. Okay. Anyone else possibly disagreeing? Okay. Wow, okay, so we're done with our issues. Dr. Cow, did you want to add anything? Okay. Anything we didn't cover yet that you want to bring up? Otherwise this will be the end of our planning session. Dolores?
One quick thing, I think.
Could you
I
get
think it'll be
closer to
quick.
your mic?
I think one of the things that has happened since we started using Bagley-Keene has been the hampering of communication between committee members in between meetings. Quite often I'll have as I'm reviewing the materials, I'll have a question that I feel like I should call one person or another, or email one person or another committee member to ask a question, and I'm always afraid to do that because I don't want to do anything that will conflict with Bagley-Keene. So I don't know if we need I'm not sure I want another training session on Bagley-Keene, to tell you the truth, but I wouldn't mind having a list of do's and don'ts. And if it's okay if I have a question about material coming up for another committee, is it okay if I call or email the committee chair or one of the committee members and ask them about it and discuss it? I
Okay.
need to know that.
Caroline, is that going to be you or Jean answering the question?
I don't mind answering. You want to reframe it?
Okay, just so if Dolores contacts one other member of the committee to ask about a particular agenda item, would that be prohibited by Bagley-Keene?
No, it's not prohibited, but we caution against individual member contacts because sometimes they can create a daisy chain communication. So if Dolores goes to Paul, and then Paul goes to Larry, and then Larry goes to David, and so on and so forth, and you get to a majority of the members, then you're going to violate Bagley-Keene. So generally, like, communications between members is easiest to kind of flow through like a staff person if you want to do it, because then they can make sure that, like, there's not like a daisy chain. But no, strictly speaking, individual contacts between members is not a violation of Bagley-Keene.
So if Dolores is self-disciplined enough to swear whoever she talks to not talk to somebody else, or at least not say what Dolores thinks, because I think that's the real problem, A daisy chain is when Dolores calls me, she says X, I call Alex, and I say, Dolores, and I think this, and then he calls someone else, and eventually we've got too many people knowing, and a decision, in air quotes, may have been made. But if Dolores just calls one other member of the committee, that's no problem.
Yeah, I mean, the one thing I would say is it deprives the public of the benefit of, the content of those discussions. So, and that's the whole point of Bagley Keene, right, is to make sure that these deliberations between members are happening in public so that the public has an opportunity to respond. So that's the one thing I would say is that, for public policy reasons, like it's always best to have discussions about matters within the CBE's jurisdiction during notice meetings. It gives the public the full opportunity to participate in your decision-making process.
Okay, and then certainly if Dolores learns some piece of information that influences her decision, it would be good for her to share that at the meeting when we discuss it.
Yeah, I mean, if it's something that she feels is important to her own, thought process and deliberations, she could definitely bring that up at the meeting. It's not necessary, I guess I would say, like she isn't under any obligation to like disclose something, but if she wanted to share it, she felt it was important and that the full committee should get the benefit of knowing it, she could share it at the meeting.
Okay, thanks. Did that answer your question?
More or less, yes.
Okay.
Mr. Chair, I just wanted to tell you that your executive summary was helpful, informative, and most importantly, I think it was very effective. It's obviously spent a lot of time in putting this together.
Thank you.
And one more thing to Amy. You don't suppose we could have the planning session in Napa next year, do you? Just a thought.
No, that's not going to happen.
That is old days thinking.
Yeah, I know.
Okay, so the next steps are Dr. Cal and I will prepare a summary of what we've concluded in a format that we can keep around to refer to once in a while. And as the time goes by, of course it can be changed. But again, it has no regulatory effect. It's just a statement of expectations. So thank you for what I think is a very lively and productive discussion, which was the whole point. That's why I put that effort into it. So let's see, I can find my place in the agenda. Okay, we've got about 10 minutes before Peoples comes in.
So we'll continue.
Some of it's me, it's pretty fast.
Okay.
Sorry?
Some of it's me reporting on the exam, it's pretty fast. I can-
Okay, so we'll finish up with the director's report.
So the next item on there is the October 2022 first-year law student examination.
Thank you, Amy. So the first year law students exam was administered on October 25th. We had 284 approved applicants for that exam. The exam, again, as we've been doing since June 2020, was administered primarily remotely. We had a small number of applicants testing at Prometric test centers and an even smaller number testing right here at the State Bar office in LA. This was our first exam using Prometric. It's a new vendor for us to deliver the test, and they have a live proctoring model. So the exam soft vendor that we were using in prior remote administrations of this exam, they record and review the applicants. Prometric monitors the applicants through a web camera. So this was a new experience for us and for those test takers. We received a lot of feedback from the law schools and from the students who were taking the exam. We have a post-exam survey that was sent out to all the applicants. That closes on December 9th, so we'll have a really good sense of some aggregate feedback as well on this new testing experience. The vast majority of test takers had no issues with their remote tests, but a small number were unable to complete a section of the exam due to issues on the Prometric end, and we allowed those test takers to retake that section at a later time. A plus side to date of the live proctoring model is that our review of incidents from that exam is already completed. And because the live proctors are able to address issues on the spot, like you have paper on your desk, you have a phone, you have a water bottle, before the actual live test session begins, the number of Chapter 6 violations we're going to issue for this exam is close to 0. Any questions? I think it's me talking about the February bar exam next. So the February 2023 California bar exam will be held on February 21st and 22nd. It will be delivered in person at our test centers across California. The applications opened on October 1st, and so far, as of this morning, we have 4,163 applications submitted, and the eligibility team is moving through all of those, with 3,141 already approved to take the exam. I encourage anyone who's thinking of hearing this live or on a recording about applying to apply soon, as some of our test centers are already filling up, and the final filing deadline is January 3rd. That's all from me, unless there's any questions. The bar exam's back to in-person.
Okay, next item is mine. So I'm going to talk about the bar exam features project. So I'm introducing this new initiative that many of you have heard today. I think there was a few presentations that alluded to that. It appeared on the exam work plan for 2023. And so this is a project that will commence in the coming months. And we plan to provide the CBE updates about this as it's ongoing. And it's one of these initiatives that Leah's encouraged the committee today to participate in, and that's to be aware of innovations in licensing and in testing. So as you know, the Supreme Court directed the Blue Ribbon Commission to explore what the future of the California bar exam should look like. And so the Blue Ribbon Commission made a recommendation to develop a California-based exam that incorporates the CAPA findings, and that also shouldn't look like the way the bar exam looks like today. So that the idea is that the testing questions and the modality be reshaped in this new exam version. So in anticipation of those changes, the State Bar began exploring specific bar exam features, which I'll get into in a minute, to see how they impact specific subpopulations. And so as part of that, the State Bar applied for a grant and received funding for that grant from Access Lex to help us do that. Could I see the next slide, please? So more specifically, we seek to understand the impact of exam modality, open book, and testing time on the test-taking population, focusing on whether any of these exam features have an adverse or positive impact on subpopulations. So we know that the California bar exam requires re-engineering of the current format in order to incorporate the recommendations stemming from CAPA, which defined minimum competence to practice law in California, as well as specified the knowledge, skills, and abilities required to do that. So again, given our commitment to ensuring that the attorney population reflects the demographics of its state, we think it's important to start exploring these. So we're going to test various exam features, and that'll aid in ensuring that the new California bar exam format is both culturally fair and allows the State Bar to achieve its mission of diversity. So right now, the current plan is to develop more exam questions that use applied knowledge akin to the performance test, where there's a reduced amount of memorization that's required for those exams. And so this is why we also plan to test the timing of the exam. So part of this exploration is experimenting on the amount of time allocated to each of the question types. The experiment also hopes to look at the impact of the modality. So I talked about, and here we're referencing in-person and remote, whether that has impact. And we already have a lot of information knowing that We had 3 bar exam administrations that were remote in the past 2 years, and we're going back to in person. So we have some information, but we're going to continue to gather more about the impact of these modalities on subpopulations. And lastly here, the open book. So the idea is to explore all of the possible variances of open book. So open book as any print material that somebody wants to bring, including commercially sourced resources and supplements, any personally created print material, and any electronic material, or even material that's provided by the California State Bar. For example, the federal rules of civil procedure being provided to an applicant. But the idea here is to test the impact of open book on the testing population. So as part of this initiative, there are 2 members from the CBE that will be working as advisors on this team. And so that includes Alex Lawrence. Wow, I'm echoing. And Paul Kramer. And so we're about to start, commence this initiative. We'll have a meeting probably, if not in December, in January. And we plan to keep the CBE updated as this initiative proceeds. All right, we have a question.
Can you define subpopulations?
Yes, so we're looking at what we typically look at when we do this type of analysis. So race, ethnicity, gender, law school type, to see the impacts of these modalities with those subpopulations.
Excellent. And as we engage in analyzing these features, is there a belief as to when we may change the California bar? Are we looking at 5 years out, 10 years out?
You know, that is one of the recommendations that the BRC is making, and it's going to include in the final report that's going to the Supreme Court. So in terms of a timeline, if that report is submitted to the Supreme Court in 2023, the timeline starts at that point. We recognize it'll take some years to develop this exam, so getting an early start on gathering information that will help improve that exam development is what we're trying to achieve here. But it's hard to say, because part of that also requires we give the law schools notice when we change the exam. Because remember, one of the recommendations also includes reducing the number of bars exam subjects from 13 to 8. That was one of the CAPA recommendations, and that's being incorporated here. So it'll be some years between exam development and notice to the law schools before we implement the new bar exam.
Thank you.
Mm-hmm. Yes, Ashley.
When we're talking about those subpopulations, are you also, I guess, specifically targeting the metrics on disabled testers, or is that not a subpopulation that's being focused on?
We've not conducted that level of analysis, but it's a good idea that we might want to bring back to this group.
Yeah, I would see that some of those modalities might specifically enhance our pass rates for our disabled law students. So that's something I would want to see.
Okay, thank you. All right, anybody else? Okay. All right, so our next item is related to our rules revision process, where we're seeking volunteers in our next 2 areas, which includes special admissions and eligibility. And we have Kathy Scher, who will be talking about the special admissions, and Audrey about eligibility.
Good afternoon. I'm Kathy Scher with the Office of Legislative Affairs, and I wanted to just give a brief overview of the Rules Revisions Project specific to the various special admissions program that allow out-of-state attorneys to engage in limited practice in California. Amy, are my slides included in this slide deck, or is there a way for me to share my screen?
Yes, Tyler, can you advance to the next screen, please?
Terrific. Sure. Thanks so much. Great. So let me start with a quick description of the programs that we're talking about, which are listed on the slide. The first 3 listed here are all part of the multi-jurisdictional practice program, which includes the Registered Legal Aid Attorney Program, allowing out-of-state attorneys to work for a legal aid organization under the supervision of a California attorney. The Registered Military Spouse Program, which allows out-of-state attorneys who are married to military service members to practice law under the supervision of a California attorney. And then the Registered In-House Counsel Program, which allows an out-of-state attorney to provide legal services to a corporation that employs that attorney. The Foreign Legal Consultant Program is a little bit different than the first three that I mentioned, in that it is for attorneys who are licensed in other countries rather than states. And that foreign attorney, if they are registered with the state bar, then can practice the law of the country in which they are licensed rather than California law. Finally, the last two programs, which are also a little different than the four that went before, are the Out-of-State Attorney Arbitration Council Program, which allows an attorney from another state to represent a party to an arbitration proceeding here in California. And that is subject to the approval of the arbitrator or the arbitration forum. And then the Pro Hoc Vice appearances law, which allows an out-of-state attorney to appear in court in a specific case. And again, that decision is made by the court in that case. I want to note that at this point, we are mostly focusing on the multi-jurisdictional practice programs and the Foreign Legal Consultant Program, and less so on the last two, although of course we are still looking at them. So I think it was discussed a little earlier on in this meeting, talking about the goal number 2 of the State Bar Strategic Plan to protect the public by enhancing access to the legal system. Increasing the number of attorneys who are admitted through special admissions programs is a key element of the strategy for achieving that goal that is laid out in the strategic plan. So we're looking at the rules and processes for application to and participation in these programs, which generally require an annual renewal, to see where those rules and processes can be revised to get rid of any kinds of unnecessary barriers that stand in the way of more people participating, to streamline the procedures so that people don't have such a hard time applying that they don't want to participate, and also just to clarify the rules and processes where needed and make sure that what we're doing now is aligned with the rules and statutes as they stand. So some of the ways that we're working on identifying possible changes that might be made are meeting with stakeholder groups that represent some of the people who participate in this program or would like to discuss the kinds of issues their members have identified as being potential barriers to participation. We're also looking at the laws of other states to see where other states might be doing things in ways that we would want to consider adopting. So next slide, please. Oh, I talked right through that one without, and then the next slide, please. Thank you. So I've listed a couple of the ideas for changes that have come up in stakeholder meetings on the Registered Legal Aid Attorney Program and the Registered Military Spouse Program. For the RLAA program, we've had a preliminary meeting with the Legal Aid Association of California. One idea that came up was elimination of the 5-year time limit that's currently in the rules that says after 5 years, you can no longer participate in that program. So that attorneys, once they entered it, as long as they kept renewing and kept being eligible, could continue in it indefinitely or possibly for just a longer period of time than 5 years. Another idea that came up was there's an existing rule that says if you have failed the California bar exam in the 5 years prior to applying to participate in the RLAA program, you are not eligible. While at the same time, there's a rule, you are very much continue to be eligible if you are in the program, take the bar exam and fail. So we want to look at whether there's a purpose to that, to barring someone who's failed the bar exam in the one situation, but not the other. For the Registered Military Spouse Attorney Program, we've spoken with the Military Spouse JD Network that represents military spouse JDs all over the country. And some of the current concerns they brought up were the requirement that under the current rule that an attorney must have a job lined up before they can be approved for participation in the program. Which of course that stands as a huge barrier because it's very hard to get a job if you cannot tell your employer that you are you are already approved to practice law in the state of California. So another question that they raised in that meeting was the level of supervision that is required for military spouse attorneys, regardless of how long they may have been practicing in other states. So these are just a couple of examples to give you an idea of the kind of issues that we're looking at and what the goals are and how we're approaching developing a proposal. We really are very much at the start of this process of identifying the issues and figuring out how to address those issues, which is why we are looking to you for your help as volunteers on this project. I'm really looking forward to working on this project, and I am happy to answer any questions you might have.
We talked about possibility of looking at, say, for example, assistant U.S. attorneys become members of the California bar. A lot of them, are probably members of the bar of Maryland, but get a job in Los Angeles, Fresno, wherever, and have been U.S. attorneys for quite some time. For that matter, well, federal defenders, I think they have to be members of the California bar. But in any event, is this also something that this committee is going to look at as well, or is that another committee, Amy?
I think that's a completely different initiative.
Okay,
This is
okay.
just looking at the
Just
existing
looking-
programs.
Okay, thank you.
Any other questions?
All
Okay,
right.
so how do you want to handle getting volunteers?
Oh, I'm going to speak to the eligibility rules quickly
Oh,
first, and then we'll talk
okay,
about
go
getting
ahead.
volunteers. So similar to the reasons that Kathy was just talking about, some issue spotting and some revision needed in our eligibility rules. Eligibility rules, for example, relate to what I was talking about earlier, where we have so many applications submitted for the bar exam, and then the team works through them with consulting the rules to see who would be approved to sit the bar exam, for example. So just the staff has gone through and done some of the initial look at the rules and wanted to come to you today just with some food for thought. So some of the rules revision with these eligibility admissions rules will just be like for clarity and cleanup. So Rule 4.3 defines general applicant and attorney applicant. Should we define foreign educated general applicant as well? That's just a thought. And this is for me to sort of tease working together with 2 volunteers soon. So, get your appetite started for some rules cleanup. Rule 4.26, general applicants for the California bar exam must have received a Juris Doctor or Bachelor of Laws, an LLB degree. So that is something that is not given in the United States anymore. That is something that is still given overseas in Commonwealth countries. But should we delete it from this part of the admissions rules, since Rule 4.3 speaks to foreign educated applicants? I think the U.S. stopped giving LLB degrees in the 1960s. So just food for thought. Next slide, please. Some higher level food for thought. We have something in the Office of Admissions called a start-over form. So a form for law students to restart their first year of law studies over. But this entire process exists just on this form. It's not codified in the admissions rules or the law school rules. This is used primarily in cases where a student has not passed the first year law students examination and wants to restart their law studies from year 1, usually at a new school. Is it time to review this process, maybe modernize the process and make it part of the rules? One other example I wanted to bring to you today is disciplined attorneys. There are no eligibility rules or guidelines in our rules related to disciplined attorneys taking the bar exam. The rules of procedure of the State Bar of California contain information on disciplined attorneys taking the attorney's examination, but there is no mention or reference to this in the admissions rules. Is it time to review this process and at least make a reference to these rules of procedure and our rules, since we do clear these applicants to take the exam? So if you have any questions about what I've presented, we could talk about that. And then similar to how we've been operating the past few meetings with the rules revision projects, we'll be emailing everyone and asking for volunteers to work with Kathy on special admissions rules revisions, or with me on the eligibility rules revisions.
So that's two separate sets of volunteers?
That's right. It can be the same person wanting to do both, or the same two people wanting to do both, or depending on what might appeal to you, you can volunteer for one or the other. Any questions about the appetizer I gave on the eligibility rules? Yes, Bethany. Okay. I think she's volunteering. Okay, I had another slide, Tyler, but it just says questions. I'm looking. There it is. So that'll just stay in your mind and you'll think about volunteering.
Okay, thank you. Let's see, did we complete? No. I'm going to propose that we take care of our persons in the audience who are interested in the People's College of the Law item. And then we'll come back to the orientation on the new rules, et cetera. That item is 0400, action to impose probation or withdrawal of registration of People's College of Law. Mr. Efting and Ms. Leonard. Yes. Oh, and while I'm doing that, both Larry Kaplan and Alex Lawrence have recused themselves, so they are excusing themselves from the room for the duration of this item.
Okay.
We'll go with this. You are the representatives from People's College of Law. For now, can you just identify yourselves?
My name is Edith Pomposo. I'm the law school dean.
Hi, my name's Dr. Kevin Collins. I'm a consultant, and I've worked with Edith for many years.
Okay, thank you. So we'll proceed with the staff report, and then we will hear from the school representatives, and then we will have questions and then deliberate.
Okay. All right, thank you. So you may remember that there was a significant discussion about People's College of Law at the October meeting. So this is the continuation of that, and toward Paul's PowerPoint Olympics, I will attempt to go for the gold by showing my screen while we're talking about this.
And please project your voice into the microphone.
Okay, and because I'm doing both, I may not always do that well, and if so, call me on it, and I will try to raise my voice. Okay, so we're working with item 0400, People's College of Law. And at this point in the process, the committee has noticed the school of its intent to either place the school on probation or terminate or withdraw its accreditation. You might see us use both terms. Those terms are used, actually it's registration. Those terms are used interchangeably. So just to quickly recap the process that the school has been through, all of the schools are required to comply with the rules and guidelines applicable to their type of school, whether unaccredited or accredited. And part of the way that the committee monitors this is through an annual report process. A second part is through an inspection process. So the inspection process starts with a self-study. The State Bar staff reminds the school of the sorts of things that will be covered in the inspection, and the self-study is the first opportunity for a school to say, hey, let's demonstrate to you with evidence why it is that we believe that we are in compliance with all of the applicable authority. So Peoples did create that. They underwent an inspection in January of 2020. They have an opportunity to review that inspection before you see it here at the committee and to provide comments. So the first time you see the inspection, you already see that comment. And so when you adopted the inspection report, you did so already understanding what comment Peoples had made. After issuing the inspection report, you did accept the inspection report. You renewed the registration, but did so with significant conditions. And the reason for that was because when you looked at the past 2 inspections, each happening every 5 years, you observed that the school each time had a very large number of recommendations. It was very responsive to the State Bar and corrected those quickly, but by the time that you inspected them again, there was a long list. So this was the 3rd time in the series in which that happened. So this time you intended to take proactive steps to help the school remember to put in place the procedures, the process, the resources that would allow for sustained compliance. So in this case, you had them to submit an enhanced annual report each year, and in 2020, they did so in a compliant manner. In 2021, the committee had concerns. The committee provided the school with 30 days to amend their report. The school did not respond or file an amended report. They rested on their report, and as a result, the committee decided to issue a notice of noncompliance to the school, as it had indicated it would do when it reviewed the inspection report. After the notice of noncompliance, the school did provide a timely response. The committee reviewed that response, and after reviewing that response, found it insufficient, and submitted and had the school schedule an inspection again. This is a non-compliance inspection. It is a more targeted inspection, focusing on the issues that have been raised throughout the discussion process rather than a full inspection in all areas. After that non-compliance inspection, the team created a report. You reviewed that report, and upon reviewing that report, gave notice to the school that you would issue a notice of that you would proceed to consider probation or termination of accreditation. Termination of registration. And at that point, the school had an opportunity to request a hearing and did not do so, but in so doing, in foregoing a hearing, the school took responsibility for the need to make changes. The school has been making changes. The school verbally indicated that they would cooperate with an order of probation of any content that was reasonable from the committee, and upon seeing the staff recommendation, issued the document that you received as a public comment from Dean Pomposo that was accepting the proposed order that is a starting point for discussion here in the committee today. So that's a little bit of the background about how we got to where we were. In October, the committee asked for a sample probationary order. The committee did not select between probation or closure of the school, but wanted to see more detail about what one could look like. The one that you have attached as attachment A should be considered as what could be the substance of the actions that a school would have to take. If adopted in this or a modified form, what I would recommend is that you approve this in concept and then allow staff in consultation with OGC to append the proper procedure, a more detailed summary of what I've just gone through here, to create the order in the way that we normally do. So that's a little bit of background, and at that point I would be prepared for any brief questions that you might have before hearing from the school, or we could turn to the school for their 5 minutes of public comment.
Okay, let's hear from the school. I don't see any questions.
Okay, thank you. So Dean Pomposo, your team will have 5 minutes for public comment.
Okay, great. Hello, everyone. Good afternoon. Thank you, Natalie. That was a great synopsis of the background history. My inception with the school on September 27th. Since then, I started on September 27th. Since then, I have been doing a needs analysis since then, and just working really hard to fix numerous compliance issues. To me, I love the challenge, having had worked in several organizations, educational organizations, and I see it more of an organizational leadership puzzle. I'm building out infrastructure, memorializing that infrastructure so that after my tenure is over, someone 5, 10, 15 years from now can take over and build upon the existing structure. In doing so, I embarked my colleague, Dr. Kevin Collins, who has extensive amount of higher ed experience in the process, because I wanted something that would not only solve the problem for now and band-aid it, but I wanted something where we can continue to build upon the legacy of PCL. And actually, just because it's an unaccredited school doesn't mean that we can't offer an Ivy League education at an unaccredited level. Those are my expectations, and I'll let Dr. Collins address the committee.
Yeah, we were very happy with the notice that Ms. Leonard came up with in terms of we're willing to accept probation. We're willing to accept that there was negligence of the school. It wasn't maybe we weren't the best. Maybe we're not the most structured people. And so we welcome the structure here. We want you to know that we're sort of want to be a partner in this. We're going to be going through and looking at the curriculum and not only making sure we meet the bar standards, but exceeding those, but doing it in a way that's responsive to the audience in which we're working in. I've heard a lot of discussion here today about DEI and diversity, and our students are very very non-traditional. We need to not only provide them a solid law school education, but we need to do that in a creative way. And so we're looking at all of our curriculum, going to revise it, set learning outcomes and expectations, and the people who do teach it will be working off of that curriculum that has been created by the school. Likewise, we're looking at expanding our infrastructure, making sure we have the proper staffing in place, and that we're also meeting, setting SMART goals and being able to achieve them. So we welcome the process to work with the bar, coming back in 6 months or a year, submitting monthly reports. Not a big deal at all. All we ask, though, is one of the things we found challenging with this process is that the bar doesn't exactly explain what they're looking for. For example, you have 11 subjects of curriculum, but you don't give us the learning outcomes for what, so let's say what we teach is the same as what other schools are teaching. If we had those memorialized, it would be much easier. There are several other things that we were dinged on, too, in which we have no problem fixing, but it's sort of like, well, get a test software. Well, that's great. Well, there's 90 million different test softwares these days. If you had more criteria there, it would help everybody be on the same page. And so that's just something that we look forward to working with the bar, even your committee, if called upon, just to create a more tangible assessment in terms of laying out exactly what you're looking for, so you can come back and say to us that you didn't meet this, you didn't meet that, but you're good over here, and then we can mutually debate how we can get there. One final thing, I was involved in the latest California Teaching Commission, the reorganization of the curriculum. If you look at CTC standards, which I think were referenced earlier, they delineate exactly what should be in each of the 9 or 10 areas. I don't remember what they were. And that's then that's organized, set up in learning outcomes to different classes. You notice the teacher education curriculum, no school is alike. They all kind of take a different twist, a different spin on it. And so, but there's an agreement of, it doesn't matter how you get there, you just got to include these things in there, and they're very, very, very specific. And the last thing, that the reason why they did this was to
30 seconds remaining.
Special needs learners. I'll end it there.
Thank you very much.
Thank you.
Any questions from the committee of either staff or the school?
I'd like to get staff's input. What was said first? Can we do that?
Sure.
Okay, first and foremost, I want to echo that we welcome a dialogue with not only People's College of Law, but any school on what the requirements are. I would say that the committee is always thinking about what you do, how you're doing it now, and whether there can be improvement in the future. And so we take any suggestions to heart. Here at this school, there are some foundational issues in terms of ability to pass state bar exams, ability to record keep, et cetera, that I think you would identify as priority. But that doesn't mean there's not room in the basket to consider additional suggestions as well. And we would encourage this school and any who has any question about a state bar staff request or a committee request to reach out to us, and we're happy to support.
I would imagine that you're reluctant to recommend any particular software product because that can get you into trouble as a public agency endorsing things. Am I understanding that correctly?
We wouldn't make a commercial recommendation. Here, in this case, students were able to take exams without locking down their PCs, so they had access to notes of any kind and not a particular proctoring scheme during that. And so most of the products available would address that issue, and the school has selected one and evaluated quite a few before making their choice.
Okay. Any other questions? Microphone, David?
The last time we were here, we discussed this, but apparently you've been in touch with Natalie with respect to accepting this challenge of probation and working with her and making sure that you overcome everything. I'm very familiar with People's College of Law. I am friends with a number of lawyers who are graduates of that school. And I hope and I pray that you too are up to this challenge and you bring yourself to full compliance as quickly as possible. Thank you. Yeah, I would like at this time to.
Well, I think there's a few more questions.
Oh, I'm sorry.
Yeah.
Mr. Kangora?
Yes, thank you, Mr. Chair. Thank you for coming today. Thank you for your ongoing participation. I think that's something that I mentioned in the last meeting, that it's not so much about the legacy, it's about the consistency. And so I think if you can intentionally show us that and maintain that level of consistency across the board, that's what's going to help us make decisions in front of us when it comes to us, so we could say, hey, this is the track record. I hear you on the standards. I brought that up before. And so, Chair, I don't know if we could put a pin on it, but I have brought that up before on one of my site visits about not what we recommend, but kind of what are the outcomes that we expect when we do site inspections and from instruction. From the K-2 level, K through 12 level, they do have that. I just don't know how, and I know we like to give the law schools a bit of their breadth of being able to teach to their audiences. I just don't know what our level of capacity is to engage on that end from our accredited schools. So that's just a comment I wanted to make to staff.
Well, did I recall, Natalie, that one of the possible work plan items is, you're working on measurables, right?
Yes, all of the offices will be looking at metrics, including ed standards, and it could also be possible. Are you hearing an echo?
Yeah.
Yeah. Somebody who's on Zoom may have a.
Natalie, you just need to mute your individual Zoom.
Turn your mic off.
Yeah, I turned off my mic.
There you go. It's good.
There we go. Thank you. Thanks very much. Okay. And then also in the self-study, we're always looking at that, and the self-study is it is a walkthrough what we're looking for when the inspection team comes on site, and we could show that to you for suggestion to make sure that the school is aware of what is expected of them.
Show us something today?
Not today, but I could bring it back in a future meeting.
So,
yes.
Kareem, I think you can be our watchdog as far as making sure that we're addressing that it's probably a longer term project to create these, but we'd appreciate your attention to that.
Definitely. I brought up when I first went to a site visit, me and Natalie had a conversation about it, and it's just something that came up. And I guess as we're listening actively to our schools and even in CS bars, seeing what their level of discourse is, because we did have this conversation on accreditation. Now I remember it was very lengthy, and we couldn't dive too much into it. But like I said, thanks for coming today. And if there's no other comment, I'm willing to make a motion.
Well, I had a question or two for the school. It seems as if one of the sources of the recurring yo-yoing of compliance is the use of volunteers and in positions where most schools would have paid employees, who are perhaps more responsive and diligent in meeting their obligations. How are you addressing that?
That's an absolutely fair point. For one of the first things I said when I looked at the school, what we've decided to do is a model that a lot of higher education institutions are taking on now, where there's multiple sections of a class. The curriculum would be designed up front. It's handed to the instructor, and the instructor then goes forth with it. So they're not responsible for creating the whole class. So that way, if you have multiple sections, you can't ensure that you ensure that there's consistency. You can deviate here and deviate there, but as long as the overall standards are being met, there's a pacing plan. What that means is there's an expectation of what's going to be covered each week. Look, things happen. You don't get to that, but you move that topic on to the next week. But it's all laid out so that there's, and we realize that our instructors have a degree of content knowledge and also field experience from working out there and being an attorney, but we don't expect them to be able to know all this stuff. So if we give this to them, give it to them on their desk, and we're happy to work with the State Bar to see what we've come up with and get feedback. We believe that should alleviate some of the concerns. The faculty being volunteer, I think it's a cultural thing here. We have a lot of really dedicated faculty who are former students. It's a model we think that can work if it, as we continue to look at that. And we really just think if we just strengthen that curriculum and the expectations of the faculty, and they just come in and teach, they do their partners in the grading, this can work. And we really believe, 5 years from now, our goal is to be on 60 Minutes and say, look, this is what the next generations of law schools look like. In terms of, look, we can have a really functioning school here that has just as good a bar passage rate as, fill in the blank here in California or nationwide.
Do you think 60 Minutes would find that story sexy?
They might. It's just
Okay.
a matter of calling it. Actually, I have a story behind that. I was part of the LSAC lawsuit because I have a disability from going back about 8 years ago. I actually contacted a producer, and it almost got bid on. So
Okay,
there's
well,
almost a big bite
I think
here,
your
so-
optimism will help you there. What about the back office, though? Because another element of compliance is getting back to us with the information you're required to supply. And I think the use of volunteers in many of those roles has also been an issue. Am I correct, Natalie?
Yes, that you are absolutely correct. And what the law school has done now is they have 2 paid full-time administrators, myself and Adriana, who is the administrator/registrar. We have also approved in the budget for a legal clinic coordinator /coordinator, who we got that money from a grant. And so there are now paid staff, and because of a lot of my experiences, organizational, building infrastructure in organizations, I've sourced a intranet where we're going to memorialize all procedures, from the registrar to intake of admissions to how you answer the phone, how to discipline students. It's going to take a little bit. It takes a little bit to organize, but I'm very confident that with this intranet that I have, and then it's also attached to a project management software that comes into your phone that's attached to the Gmail. So through Zapier, you could actually customate it so that it's automated, so that you don't miss a beat, if you will.
Okay, thanks. And then my final question is for staff. Is measuring their coming into compliance in August of next year, that seems like a relatively short time period. I was wondering if it needed to be longer, because in effect, they have to report to you, it looks like, in the early spring, so that you can get something to us in June. I'm just wondering if that's not too short a period to achieve all this.
Well, this is what this is based on, and this will help you make a decision about what will be the best. The challenge with the school is that you've seen it come in and go out of compliance. And you saw that in general over the longer period, but even during this heightened scrutiny period of the 2 years, it happened again. And in some sense, the response you're seeing now is inspiring, but it is consistent with that pattern. As the school realized that closure could be a possibility, starting around Memorial Day, the school has taken monotonically increasing steps to improve its performance, but will it stay? And so we struggled with thinking about what is the best, to have a short period to say that if that pattern recurs for even a fifth time, can the committee act without going through the whole process again? And so that was the idea behind a shorter term versus a longer. Because in some sense, they've already been, while not on probation formally, they know that they've been under heightened watch over the last 2 years, and they have not been able to accomplish these procedures. So this is a chance to say truly, does the school have the intent and capacity? And if you determine you need to extend it, you can do so. But this will require that work be done immediately, and that students that are enrolled or students that may want to enroll can have confidence.
But it sounds like you're saying proving compliance next year could just still be part of a pattern. And if we then say everything's good at that point, and the pattern continues to the rest of its cycle, and all of a sudden they're out of compliance again, we have to go back through the whole process. So I'm just wondering if we shouldn't have a longer probationary period, perhaps measuring compliance at intervals to test for repetition of the pattern versus continuous compliant practices.
That's definitely a possibility. Another possibility is to set the school for annual inspections.
Okay, Alex?
I have a couple of questions for Dean Spiro. You understand the committee can't give away unlimited jail-free cards. You understand that. At the same time, the committee is not going to put all the roadblocks in place that basically set you up to fail. That's really not the intent either. But absent unique and extraordinary circumstances, we also cannot give specialized exceptions to schools, or we would be seen as engaging in discriminatory application of the rules. The rules are there for a reason. And so with that as the backdrop, what do you propose as the concrete game plan by which to measure the school's compliance of the admissions rules so that this is not an end run? And I would like the dean to address this directly.
Sorry, you said Dean Spiro, so I looked back.
Oh,
at
I'm
Dean.
sorry.
No problem. Yeah, so, yeah, do you mind repeating your question? I'm so sorry. I thought really that you were perhaps addressing him.
Oh, it's
Dean
okay.
Spiro behind me. Do you mind repeating your question?
Sure.
I'm so
or
sorry
someone
to
with
make you do that.
authorities.
Yes.
So the question is, with that as the backdrop, what do you propose as the game plan by which to measure the school's compliance of the admissions rules so that this is not an end run?
Well, that is a very loaded question, because in order to measure compliance, and I'll tell you because I've had my fair stints of WASC accreditations, program quality review from the state when I was in LA Unified, programmatic accreditations from the allied health fields, the Bureau of Post and Secondary Vocational, BIPI. So having in my 24-year career, there is not one set measure, and the question kind of makes me wonder if perhaps a committee, with all due respect, may have needs a little bit more education and understanding in addressing education programs, because education is very nuanced. In fact, this is what I was trying to explain to my dean, where I finished my LLM when I was writing my research paper on an education topic. And what I found out from my research is that it's very nuanced, highly nuanced. So there is, when those committees come in, the accreditation teams come in, they look at several factors. One of those factors is a self-study, which I have been involved in creating those self-studies, and I welcome them because I stand 100% by my work. However, what Dr. Collins and I both are in agreement with is that when those accreditation committees come in, they have an established criteria. They survey the school culture, they survey parents, they survey students, they get surveys, they have site visits, they come 2 days, 3 days, where we put them up at the hotel and they cater lunch to them. They walk around the classrooms, they see instruction, they have rubrics for teachers. So it's very, very highly involved. When I first started, I was confused, and I'll tell you why. Because I told my colleague, Adriana, where are the standards? What are you talking about? The standards. She didn't know what I was talking about. And then I went on Google. I told him, I can't find the standards. He's like, maybe there aren't any. I found the ABA standards, but I couldn't find the state accredited standards. I thought I was missing something, but then found out there weren't any. So in all the in the allied health fields, they have standards for people that are, I walked into an allied health field situation where I was supervising 3 campuses as the associate dean. I don't know at the allied health field. I don't know dental assisting from massaging from medical assisting, but what helped was that they had delineated standards. So I knew the skills. I knew how to evaluate instructors. I know how to engage learners. I've taught teachers how to teach for many years now. So I'm sorry I can't give you one precise way to measure schools because it's highly nuanced. My suggestion is to perhaps look into the WAS accreditation standards. BIP started to change in the last couple of years, which is why they hired me in 2010 at Northwest College, because they were moving to it was an active bureau, and then they moved into that area where they're becoming more sophisticated. But WASC has an excellent process. And yeah, I'm sorry I can't answer the question in just like a couple sentences. And I think Dr. Collins has a couple more things.
Yeah, I always say never let a crisis go to waste. And so here's a perfect example where I think we've identified, and one of your colleagues here has identified some deficiencies too. So maybe we could work with you guys to figure out, we're going to bring, I think we're out of compliance in 3 minor areas, but we're going to be revamping the curriculum and the other things. And we'd be happy to work with you in terms of a case study, in terms of how do you build that. And then it's objective criteria then that can be applied to other cases. Now I understand this is our 5th round, so if probation needs to be extended for 2 years, that's fine. Or whatever the case may be. But I think we can reasonably work together here, and we're happy to share our knowledge and come up with something, and you bring in 3 or 4 people that are completely outside of this process, so we're not biasing it. To be able to look at it and say, look, here's what you're doing really well, here's what, it's kind of your meeting criteria, and here's where we think there can be improvement. Give us a reasonable amount of time to make the improvement, assuming that it's just a couple different minor areas that really, they're material, but, scheme of things, the house isn't burning down. And we work through that, and we can not only will we be better as a result, I think you guys will be positioned in a better situation to evaluate other comparable schools that are in our similar situation or different, whatever the case may be.
So Natalie, since the reduction in the cut score, has the school improved in terms of the passage rates?
It has not. Unfortunately, the July 2022 pass rate for the school was 0%, and in the last 3 years, 2020, 2021, and 2022, approximately 4 people from the school have passed the bar exam.
And that's even though this is after the cut score has reduced from 1440 to 1390?
That's correct.
Thank you.
So yeah, I think what I'm getting at with my question, and I thought maybe Alex might have, it might be a theme in his as well, is we need to see two things: demonstration of compliance, but then sustaining that compliance. And that's why I'm wondering if we can achieve all that in the short period that's currently proposed. And it probably involves, some kind of test, middle of next year, thereabouts, but then also to come back after another year or so and see if the status quo has been maintained. That's at least what I think I'm looking for. And it sounded as if the school was understanding of that concern and willing to accept something like that. And they are nodding their heads yes. So those are my thoughts. Any other questions or comments before we have a motion?
We think that's a fair compromise, that we can reach. So yes, just want to reiterate, we do agree with you.
Thank you. Any more questions?
Paul, can I ask something? So the school noted that there were a few areas that needed to be addressed, or areas of compliance, as well as the fact that there were no standards, right? Or you could not locate standards that you needed to achieve. And I'm just wondering, Natalie, what kind of information have you provided to the school? And also, is there an agreement that there's only a few areas of compliance?
Sure. So the applicable standards are the rules for unaccredited law schools and their guidelines. It's an approximately 60-page document. In addition, we provided them with feedback as to their compliance on the various areas. We've identified 10 specific areas that need extra attention, including outcomes on state bar exams, including the ability to provide the 270-hour requirement program that the school needs to offer, et cetera. And you can see those 10 areas enumerated in the probationary proposed order on attachment A.
Thank you. I just want to make sure that the school has the tools it needs and knows what it's striving for, if that hasn't been clear yet. Thank you.
And so we have to apply the rules as they exist today. Maybe there is some need to provide clear standards, although I would suggest that for everybody who wants clear standards, there's somebody else who wants to be left alone to do the job the way they think is best. So, but we are talking about reviewing the unaccredited law school rules in the next year or two. So I encourage you to monitor and provide your thoughts in that process. Any other questions or thoughts, Natalie?
I mean, a clarification I might suggest is that one thing that I would say is that the rules do not, for example, say, hey, this is what you need to teach in torts. Rather, instead, you have the references from exam development as to what will ultimately be covered on the bar exam. And the majority of the curriculum comes from looking at what will ultimately be on the bar exam. Here, in terms of the non-compliance is relative to the standards that were identified. And as to the curriculum content, the exam development standards are what would provide that here. And I'd be happy to work with the school, as to those details as I would with any other school. And then you mentioned length, and we can talk about length of any period of time. I just wanted clarity about what you were thinking or asking the committee to propose so that we can document it correctly, but also to understand that this team that you see before you has been in place for only 8 weeks. And so if it is not able to achieve what it intends to do, and we haven't heard timelines in the discussion today, you may want to retain the ability to act quickly.
May want to, sorry, repeat the last.
You may want to retain the ability to act quickly. So a short probation allows this team the opportunity to show that it can do what it says it will and what it feels it has done in many other settings. And if not, you can take quick action as to whether or not the school's allowed to continue.
Okay. Yeah, I understand short probation means we want the proof relatively soon. We want them to make the improvements. But what it doesn't do is indicate that we're also looking for sustained compliance.
Right.
It implies that if they make the proof that they are now in compliance, we will take them off of probation. When in effect, I think I'm suggesting that we need to at least be clear that you're not off the hook yet, because we need to see that compliance sustained. And I don't think that formulation that you have proposed achieves that second goal. But I'm just asking the question. I really would like to hear from the committee about what their preference is.
Are you suggesting it's a longer probation time, or?
Longer probation with a check-in in the middle. Check-in for compliance, and then a later check-in for sustained compliance. So if we don't have compliance at the first check-in, then we might consider, withdrawal, for instance. But even if we have compliance, we want to see that they maintain it.
So, Paul, the proposed motion has certain things have to be done by the spring of '23, and then we have this back on our agenda on June of '23. So the proposal would be maybe in June of '23, we would then set a new probationary period based on the results we've received as of June '23. Say, we wouldn't be basically saying probation is going to end on August 1st. It's just on June 2023, we will consider how long probation is going to continue. Is that what you're suggesting?
Yeah, and the current formulation doesn't indicate that that's a likely outcome at all. That's what I'm saying. It kind of misleads people into thinking that you can just prove your compliance and then you're going to be returned to compliance status, and we'll see you in another 5 years for an inspection.
So under the proposed motion, under the first further moved, rather saying probation through and including August 1st, 2023, we'd strike that, just on probation as set forth in attachment A, and then down at the end maybe say, reviewed at the committee meeting on June 2023, at which time the committee will rule on continuation of probation, something like that. Trying to figure out how to modify the motion.
Paul, sorry, Natalie, did I interrupt you? I was just going to suggest that the rules require a fixed duration for probation. So if you wanted to extend probation for a longer period of time, you could do so and add interim deadlines within that time frame.
Yeah, I think that's what I was anticipating.
And in terms of the time periods to choose, part of what we were trying to do is keep student welfare in mind. So this August 1st thinks about this school year, and then August 1st, 2024, protects another school year, so to speak. So you may want to look at it in school year increments.
So as increments, annual increments from August?
Right, that's not required. You have flexibility, but some of the staff thinking there was to alleviate any student anxiety that the school could be closed in the middle of a semester. That's always a possibility.
Oh, okay. No, that's a very understandable concern. But I don't want students thinking that this is likely to be resolved. If we really believe that we need to test for sustained compliance, unless we believe that sustaining it is through just the middle of next year, we need to be clear with people that we're not going to be fully satisfied until they come into compliance next year and they stay in compliance for, say, a year. And so I think we need to set the ending date of the probation for that that time when we could actually be willing to say, everything's good, thank you, good job, and you are now no longer on probation.
But I think the suggestion here is that if we say August 23, then the students know they've at least got this next year, but then say, but sometime between June and August, we will extend you another year. We're not going to end probation at August 1st. So So that's just what we want to add, right?
Yeah, but then why not say that the probation is going to 2024 in the first instance?
Because you're giving them more time than maybe we want to give them to.
No, we can have, well, we could have 2024, but you have to check in April, June, whatever, of next year, 23. And if you don't show compliance at that point, then we can move to terminate. Because there was a provision in the attached order, I think, that said we could terminate early.
Yes. We can do that. A flip, I'll tell you, is that we received feedback from more than one student that indicated they heard from administrators or volunteers. Oh, don't worry, they won't close us, they can't close us, it's just probation, it won't be a big deal, you won't even notice. And I got many distressed student phone calls that I had to handle in that way. So I think sending a clear message that students can find from the committee is helpful, and helping the school to more forthrightly communicate is helpful. And toward that end, I would like to compliment the school that after October 19th, they did send the committee's direct order out to the students, and it was a big help.
Okay, yeah, but I'm not sure I see how, if you're saying that it's okay to say August 23 is the end of probation, I don't see that connection.
Oh,
I mean,
it helps the students understand the reality that this school could close at the end of the year. If you have a 23 end, but if you feel that a longer tail is necessary to give the school time to do what it needs to do, then you absolutely have the authority to extend it.
I mean, is it better for them to know now that this uncertainty may exist until 2024, or just find out a year from now that it's not over, which is more honest? I feel like I'm too involved in this discussion without any sense about whether others share my concern, which should maybe be the first question.
Well,
Bethany?
Yeah, I'll just say I do share your concern. I just don't want to say anything because we're talking about it now, but I do think that, sustained compliance is important. I think that we should account for that in the motion before we vote on it.
Okay,
what
so
if we were to do, what a possibility could be to keep the 2023 time period and indicate that you will likely recommend annual inspections for the next, 5 years.
So we bring
until
this
the next,
back in a year.
right?
But okay,
the
but the
foreseeable
annual
future.
inspection device means that if we find a problem, we have to go through this whole process again.
You can make a term of probation, we would cover it off with OGC, that much as here, there could be an expedited non-compliance process because they have this notice at this time.
Okay, so it sounds as if you're, regardless of what we decide, you're proposing that an order or the exact terms of the probation order be drafted after we decide. And would that have to come back to us then?
I would propose that if you agree in substance, that it could go forward today. We intended to put procedure. If you're not sure about the length of time, then I would ask Jean if that's something that would need to come back here, I would assume.
The CBE has to fix the terms of probation, so yes, that is something that the committee would have to decide.
So we have to come up with it. I suppose what we could do is we could pause the item and you could bring something back to us, say in the morning. I don't think that's really convenient for the school, but then we would have something that we could see and vote upon.
We could do that. We would just still need guidance on the length of time that the committee is thinking about. And I do want to be clear that you do have full flexibility as to the length of time, and I'm happy to create something in response to the amount of time that you think is appropriate.
Okay, well, my sense of the room, mostly from an absence of comment to the contrary, is that we intend to impose, regardless of when we say probation ends, we intend that it's going to last for about a year, well, until August of '24 at least. And so if we said that probation ends at 23, I'm too loud, you're saying?
No, I'm asking Devin if she can mute me because I feel like I'm.
Okay, so if, regardless of what they prove regarding compliance middle of next year, come August, we would be intending to extend their probation. It sounds like, because we still haven't been able to test for sustained compliance. So given that, I think we should just set the period to the following year, because that's just fairer. And also, it's one less item we have to discuss on an agenda on our, in our August, well, I guess it'd be our June meeting. So why not save ourselves that effort? So I don't think it's appropriate for me as chair to make the motion, but my proposal would be to set the probation to end on August 1st of 2024, but to have them provide proof of compliance as you described in the proposed order next year. And then you need to add a provision to review their sustained compliance, I suppose, in June of 24. Does that cover all the bases?
Well, and to review the progress still in June of '23, the way it's written. Add June of '24 in there as well.
So here's an idea, Paul.
Yeah, Audrey, you're looking at the motions, but I think the operative language is in the attachment. That's the proposed order. So I'm speaking to what the order should say. Dolores?
I'm sorry, I had one more suggestion, to be fair to the school, if possible, that we could end probation of next year, May and June, before the summer begins. The summer is our admissions process, enrollment, so it's not prejudicial to the school. I'm in agreement, a year later extending probation, that's fine, but if we just end in May or June of 2024.
So June 30 would be okay?
Yes, or May 30th.
Well, June would be after our June meeting, so
Yes, that's fine.
gives time to discuss all these things.
Yes, that would be fair. Thank you.
We could work out timing, but May 30 would be very challenging for you to review.
That's why I got you June
By the-
30th.
Yeah.
So they would have to show you their proof in, say, April of sustained compliance, which is about a year from when you're going to get the proof for next year.
Okay, can you read, is this large enough to read? No, that's too large to read. Okay, can you see this gray part? Here's a potential wording you could use. Move that the committee places the law school on probation through and including August 1st, we might make this June 30, 2024, with the understanding that the law school must demonstrate that sufficient progress has been made toward compliance, or its registration as an unaccredited law school will be withdrawn, with the law school's progress to be reviewed at the committee meetings in, it sounds like April, June 2023 and April 2024, and agree to submit to annual inspections thereafter until the committee is satisfied that compliance is likely to be sustained. How do you feel about that?
I'm less concerned about the annual inspections thereafter because we've, presumably they've met the test for sustaining their compliance, but I'm open to either way.
I'd like to keep the annual inspections in.
Okay. Do you want to make a motion?
Then I'll make the motion that's attached to the 0402 with the following modifications, if I can read them.
Are we in a place where we still need to put all this to paper and bring it back, or Natalie, well, I'm not sure who, council, are we clear enough about what we're doing?
I'm going to defer to Jean, but I feel like, yes, we're okay.
we're gonna have a question though of what the committee's definition is of sufficient progress. That's very vague, you know, cause we could do our best to believe we're in compliance, you guys could have a disagreement over one or two items. And it might be just a misunderstanding, you know, maybe this is really just a minor thing, so I think we need to, if we're kind of at that edge of falling off the cliff, and you taking away the law school's license, we need that registration, we need that clearly defined for us, so that way, I think your general counsel's office, I think, would want that as well.
So it might be helpful, Dr. Collins has just been involved about 6 to 8 weeks. It might be helpful to direct Dr. Collins to the 10 probationary elements on the attachment A, where the review will be focused, but also part of what the school needs to show is a proactive understanding of the rules and a structure to remain in compliance as to all of them. So I do believe it is set forth there.
And Paul, to respond to your question, and I think Natalie deferred to council on this, but we are going to need a motion regarding whether or not the committee finds the school to be in compliance or not. And so I think Natalie's setting up the motion now, but if you need I'm happy to read along to make sure that it's accurate as you guys were just describing it.
Okay, do you see it on the screen?
I do. So I think we need to change August 1st to June 30th.
Yes.
And then we need to add
2024.
in at the committee meeting in June 2023 and April 2024. And the next further move, the committee will need to decide whether those progress reports, they want to order additional progress reports for the 2 years or just through spring 2023.
You may want to leave flexibility of time as to the actual scheduling if you're making the probation longer. If, for example, they need 4 weeks to complete the intranet or something like that. You might want to change it to spring 2023.
In order to get to us with your thoughts in June 2023 and April 2024, when do you need them to give their information to you?
I would suggest April 2023.
Okay. And then when we come to June you didn't make the change in the second further move, that one to June 30, 2024 yet. It says August 1 on the first line.
I think, yeah.
So do we need some kind of inspection in 2024 as well, or how will you know whether they've sustained their compliance?
Jean, can we have a request for a 2024 inspection without setting the time based on what's determined through the 2023 inspection? Like this?
We don't have to set the date for the 2024 inspection. My question would be whether you intend to have a self-study and an inspection in both 2023 and 2024. For clarity, Natalie, I might just delete in the first further move, I might take out the stricken part just for sake of clarity.
So Paul, the change to make a courtesy to pupils to move it back to June 30 makes it difficult for staff to do an inspection, so you would be relying on the school's representation.
Why is it difficult? Because it's not between semesters, or?
If June 30 is the date, that means it comes back to the committee in April, which means the inspection must be completed in February, which means it must be conducted, not during final exams or the start of the term, in November. And so that's probably too early to be useful.
Okay.
You may find it more instructive to keep that August one.
Would a remote inspection be utilitarian at this point?
It's not so much whether or not it's remote, whether it's remote or in person, we would be challenged to have enough time and also to give you enough space in between, if it were to be sooner. So it would be staff's recommendation to keep that August 1, 2024. But
Maker of the motion, what do you?
At your discretion.
So I gather the school is worried that the uncertainty will affect its interest of prospective students in the course of study.
That is correct. And since that is one of the areas that the staff has addressed as an area to work on, it would put us at a greater advantage if the sooner we come into compliance.
I don't understand that staff identified recruiting as an
No,
area of concern.
the staff identified that we were, the financial viability of People's College. So we're tuition dependent. So the sooner we can come into compliance, then the better for us financially. So if we extend to August, then that cuts into our enrollment period and our admission cycle for the next year. But
As a practical matter, Chair Kramer, in the last 4 years, approximately 11 students have reached the 4th year at the school, and 4 have passed the bar. So I think that you might want to prioritize the performance.
Prioritize the
Performance of the
Performance.
school, and they've been able to sustain with that level of student body to date.
I mean, I'm on the fence about the date. On the one hand, we are very concerned about sustained compliance and our ability to measure it. But given the lag time between an inspection and when we find the results, we're not, in effect, Natalie, you're saying that we're really measuring sustaining of the compliance in November.
With the earlier date, yes.
Yeah.
Otherwise, we would do the inspection in the spring and bring it back to you in June. So where they've had a whole school year. I think you have a.
Mr. Chan?
I mean, extraordinary times calls for extraordinary measures, but I would like to know at least sometime next year, even on a very high level basis, as far as how much they have achieved. I don't want to wait until 2024 for me to look at the report and then find out exactly how much progress they've made. I don't want to wait that long.
No, this has a progress report next year still.
So what I would like to propose is to have at least some high-level in-person inspection to take place, let's say in June or August, even if the report is not ready, but at least someone, whoever will be conducting the in-person inspection, can come back and report to the committee about the progress that has been made, right?
Yeah, and
Is there?
It does contain that. It does right now contain a spring inspection, probably April, to be
Yeah.
brought back to you in June. Is that?
Yeah, spring is a little too early, it's what
Oh,
I'm saying.
okay.
Because right now, we're only looking at 4 months from now. That's very little progress that they could possibly make. And so I do think it would be worthwhile, whether it's in June or early fall before school starts, to see what they have in place. And so they can report back to the committee so that we're not, if there are tweaks that we can make and propose and suggest at that time, I think the school will find that very helpful, instead of waiting until June 2024 to find out none of these work, and so it's too bad.
Well, but the current proposal is to find out if they've achieved compliance in June of next year, and then test for their having sustained it in the next year. So it sounds to me that would meet your concerns.
But I thought Natalie said if we find out in June 2023, that means we have to do the inspection in April.
Well, you're right about that, yeah.
That's
So,
too early, in my
okay.
opinion.
So then we need, so the check-in date should not be June 2023, it should be August or October?
Right. Or in the alternative, you can set the June dates, but not with the benefit of report, but someone who can actually report back verbally to the committee in June about the progress that has been made. It's an alternative. Otherwise, August, early fall works.
So Natalie, could you provide that information for us just on the basis of the monthly reports?
We certainly can try and structure it that way, yes.
Okay, so then maybe we could have we could have the monthly reports, a check-in in October, and then the further check-in in, why couldn't we check in June of 2024 if, it is right before the end of probation, but, and it does create a bit of uncertainty. But is that impossible or just risky?
I don't think it's impossible. I think it's possible. And so what I'm hearing is to substitute the monthly reports for an inspection. Is that what I'm hearing?
Well,
and then to provide updates to the
right,
committee?
Keep the monthly reports. You get back to us in October about whether they appear to be achieving compliance. And then we have an inspection, I guess a little bit later. January of 2024 would be good if it was possible. And that informs our final decision about whether they have sustained their compliance.
And the final decision can be in June, correct? June 2024?
That's the plan, or the thought.
Paul, I just want to remind you that under Rule 4.267, at least 30 days before probation expires, the committee must determine whether sufficient progress has been made. So the meeting will have to take place. The meeting at which a decision is made has to take place at least 30 days before probation ends.
Right.
So with an August date, you could do the final decision in June.
That's right.
Asking the school, of course, you said August 1st, is July 31 probably isn't even any better, right?
No, I'm a little confused now, to be honest with you. Are we still sticking to the June 2024 since we're stretching it out and then just trying to end at that June 30th?
Well,
so Dean Pomposo, what might help is that the end date of the probation, the committee is required to provide you with feedback at least 30 days prior, but they have a static meeting schedule. And so in order for you to have an update from the committee in June, your probation must end at least 30 days after that. That's where we're getting the August 1st. Does that help?
That helps to explain, but it doesn't help the school. Is it possible? I know I'm pushing a little bit here, but if we could we're really tuition dependent, so we would like to end probation as soon as possible. So that's my only concern. Could we?
I have a staff point of clarification, though. If the concern is tuition dependence, what was represented at the non-compliance inspection was that the school was planning to add additional staff through a fundraising plan that included a sale and grants, and so there were other streams. But now what we're hearing is that the school is very tuition dependent, so that calls into question the staffing plan on which the probation recovery is based.
With all due respect, what school is not tuition dependent? You have down the street USC that is.
Absolutely tuition dependent down the street. Every school is tuition dependent these days. So that's not a fair marker. When we also speak to, we also are in the process of selling our building, which is going for about 2.6 million. I don't think that's gonna be an issue. What we're talking about is that we need to get a class in of 20, 25 students, because there's attrition for any number of 90 different reasons, including not passing the baby bar. So that's what we're talking about. We're not talking about a financial model that's not viable. We believe our financial model is viable. And it's not necessarily outlined in your standards what financial viability looks like. But we can argue that back and forth, but we're financially viable right now. We just want to make sure our students aren't misled when they're looking to come to law school in which is the prime seasons, the spring and the summer.
Paul, could I make it just a suggestion for those of us appearing remotely? So because this is supposed to be the committee's time period to discuss, I understand if the committee or staff has specific questions for the school, but if you do have a specific question for the school, can you just make sure that that's clear and that you announce that you're, asking for specific feedback from the school, and otherwise just limit the discussion to the committee members, because it's really supposed to be the committee's opportunity to weigh in on the
Okay,
motion.
sure, we can do that.
Thanks.
Okay, Mr. Efting, you're making the motion, so I'll let, one option would be ending June 30, 2024, and then that would mean we would have to test for continued compliance in, I guess, April of 2024. Another option would be to extend the probation through August 1 of 2024, in which case we could consider the continued compliance in June 2024. And Natalie, you need to take out August 1 on that second paragraph there and make it just, it's just the name of the month, not that particular date. So it would be June or April there, wouldn't it?
Here?
Yeah, you're talking about the committee meetings, so
Oh, I see.
April or June. Okay, so so which do you want it to be? It would be April as it's written with a June 30, 2024 probation ending date.
Okay, so you're right, it's my motion, it can be voted down, but it'll be my motion at this point in time.
Right.
I'm gonna ask staff, if staff prefers August date, what is staff's preference there?
Our staff's preference would be August.
Okay, that's gonna be my motion. So my motion will be that the proposed motion is set forth on item 0402 as on the agenda, is my motion with the following changes. The first further move will now read, further move that the committee places the law school on probation through and including August 1st, 2024, with the understanding that the law school must demonstrate that sufficient progress has been made toward compliance, or its registration as an unaccredited law school will be withdrawn, with the law school's progress to be reviewed at the committee meeting in October 2023 and June 2024, and agree to submit to annual inspections thereafter until the committee is satisfied that the compliance is likely to be sustained. Now, then the next paragraph is going to change as well. It's going to say, further move that the law school be directed to provide monthly progress reports to the state bar on the first of the month as to each element of probation during the full term of probation, and to provide a self-study and submit to an inspection in 2023 and a self-study and inspection to be scheduled in spring 2024. That is my motion.
This is Bethany, I'll second.
Do you want paragraphs?
I don't, I thought we were just going to have one inspection to inform the final determination is.
No, that's my motion currently.
Okay.
I think that's the way it should go, and I believe we have a second from somewhere?
We did, Bethany. Okay.
Clarify whether or not
Okay,
you
sorry.
include the last two paragraphs or.
Let's vote.
Well, Harry, one second, there was a question here.
Natalie has a point of clarification.
Did you add those? Okay, so I'm sorry. There are two more paragraphs I have to add to this. I apologize. Next paragraph, further move, and I apologize for my reading, that the law school be directed to clearly advise the public, prospective students, and the current students of its status and probation affirmatively and to clearly, including attaching a copy of the probationary terms to the student disclosures, web disclosures, and web homepage, and in communication shared with prospective students. Further move that the committee reserves the right to terminate the probation prior to its scheduled conclusion if the law school fails to make or sustain adequate progress.
And I'm sorry, James, just because you've read all the paragraphs except the first, which is essential, would you mind reading the first paragraph as well to ensure that it's included in your motion?
Sure. Move that the committee of bar examiners finds the People's College of Law is not in compliance with the unaccredited law school rules, but it has made perceptible progress toward compliance.
This is Bethany. I'll second that.
Okay, let's take the roll. Mr. Chan, did you have a?
Yeah, would you accept a friendly amendment?
I'll listen.
I appreciate that. That's all I'm asking for. I'd like to change the date from August 1st, 2024 to May 30th, 2024. And also right below, a couple of lines down from June 2024 to May 2024. And my amendment is really to accommodate the school's thought process about being tuition dependent. But I also believe that this raises stakes on the school and further incentivize them to make sure they have sufficient progress in compliance with the rules. Again, all of these are sort of the carrots on the stakes to be the, looks like Natalie has a question.
Oh, schedule issue. You have the committee reviewing this in May, but you have meetings in March and April, and then not again till June.
And you have the 30-day requirement, so it would have to be April of 2024.
Then let's do April 2024.
Okay.
Thank you. So my amendment stands for the first one, amending August 1st to May 30th. And then the second amendment is from June 2024 to April 2024.
Okay, assuming that our parliamentarian has gotten those changes, my next question to staff is that workable for staff?
It's workable. Whatever the committee chooses will be made workable. What it does eliminate is the possibility to do a second inspection in 2024.
Well, this is the risk that the school is willing to take, and I will take their words for it, that they're willing to do everything they can to meet the sufficient progress prong of this requirement. So, you can't really have the best of both worlds, I would assume. So if we can't have the second inspection, then they will have to do more to meet the requirement.
I'm willing to accept that modification. Bethany?
Thank you.
I will second that amendment.
Okay, so then the motion currently on the table is to adopt the language that is shown on the screen with those new dates. Please take the vote.
Dr. Bolton?
Yes.
Robert Brody?
Yes.
Dr. Cow?
Yes.
Alex Chan?
Yes.
Jim Efting?
Yes.
Kareem Gangora?
Yes.
Judge Guerrera?
Yes.
Dolores Heisinger?
Yes.
Judge Herman?
Yes.
Larry Kaplan? Alex Lawrence? Esther Lynn?
Yes.
Bethany Peak?
Yes.
Ashley Silva Guzman?
Yes.
Vince Reyes?
Yes.
David Torres?
Yes.
Dr. Wilcoxon? Chair Kramer?
Yes.
The motion passes.
Okay, thank you, and thank you for coming.
Thank you.
Thank you, everybody.
Okay, so now we're going to go back to where we were, which is the presentation on the recent changes to both the rules of order for our committee and the public comment policy. Jean or Caroline, I don't know who's going to start.
Thanks. I will go ahead and start. Is there any way that Devin could pull up the presentation on the screen for me, or do you need me to share my screen?
Oh, Tyler has it.
Yeah.
Oh, Tyler, do you mind pulling up the
Yes, 1 second.
Thank you. And Paul, I just want to give you the option because you guys have been covering so much today, and there's still a lot more to cover on the agenda. I was kind of thinking I would go through it relatively quickly, and then people could review the slides in their own time. And it seems like many of the members are already kind of familiar with Rosenberg's rules of order, because I feel like you guys have been exercising your knowledge in that just over the last item you were discussing. So with that, does that work? Is that okay to just spend short amount of time, offer people to ask questions, and then have people review in detail in their own time?
I think we can try that. We can always come back with, we could have a question and answer session on our next agenda, maybe if we need to.
Yeah, and I think questions will kind of arise organically as we all get used to the new procedures also.
Yeah, we're going to learn about these by making mistakes, I think.
Yeah, that's right.
They'll be there to save us.
Yeah, thanks for your vote of confidence. Okay, so next slide, please. The Board of Trustees at its November meeting made various changes to the Board of Trustees policy manual, and some of those changes will impact the business of the CBE. One big one is that instead of using Robert's Rules of Order, we will be using Rosenberg's Rules of Order as a guide when conducting meetings. This should be good news because they're actually a lot simpler than Robert's Rules of Order, and they're much shorter as well. Next slide. So under Rosenberg's Rules of Order, a quorum is a majority of the body. The role of the chair is to facilitate meetings using the rules of order established by the body. And as Paul mentioned earlier, the chair has the full right to participate in the decision-making of the body, but should strive to be the last to speak at the discussion and the debate stage, and should not make or second a motion unless no other member of the body will do so at that point in time. And that's, again, just to continue to act as a facilitator during meetings while still voting. Meeting format, this is a little bit different, I think, than what we've been doing, but not terribly so. So the chair will announce the agenda item number and name, and invite the presenters to report on the item, including any recommendation they might have. Then they're going to ask members if they have any questions of clarification. And then the chair will call for public comment, which we'll handle in accordance with the Board of Trustees policy on public comment, which I'll get to. And then after that, the chair invites a motion and announces the name of the member who makes the motion. Next slide. Tyler, do you mind hitting the next slide? Tyler? Oh, looks like you got frozen. So, okay. We're backtracking. I will let you know when we hit the right one. I think it is hit 20. Yeah. And then only after the motion is made, then the chair determines if there's a second. The chair makes sure everybody understands the motion by asking the maker of the motion to repeat it, by repeating the motion, or by asking the meeting secretary to repeat the motion, and then discussion happens. So I feel like this is different because what we've been doing is having discussion, then a motion is made. Rosenberg's recommends that you first have a motion after clarifying questions are asked, and then have the discussion on the motion after. And the point of that is to help focus the body's discussion on the motion that's on the table. So if it seems like a good place to end the discussion, the chair takes a vote or calls for a vote. And we do a roll call vote on teleconference meetings pursuant to Bagley-Keene, so we'll keep doing that. And unless otherwise unless a different rule establishes otherwise, a simple majority is all that's required to pass the motion, and the chair then announces the result of the vote. Next slide.
Question,
Mm-hmm.
the majority of those present or of the membership of the body?
Present and voting. So that is how a majority to pass a motion is calculated under Rosenberg's. So that means anyone abstaining would not be counted. So I just mentioned best practice is to do the motion before discussion. I think that'll take some adjusting to, but I think we can do that. And motions are made in a two-step process. Chair recognizes the member wishing to make the motion, and then the member states, "I move," followed by the member's desired action. You guys are all familiar with that. Motions are initiated in one of three ways. The chair invites a motion, the chair suggests a motion, or the chair makes a motion if no other member steps forward to make a motion. Next slide. There's three basic types of motions. The basic motion, which just sets forth what the member hopes that the action will be. A motion to amend if a member wants to change a basic motion, and then a substitute motion if a member wants to completely do away with the basic motion on the table and put a new motion before the body. We just saw the friendly amendment in action, and everybody who participated did it perfectly. But basically, if you want to make a friendly amendment, you can suggest a friendly amendment, and if the person who makes the motion accepts it and the second accepts it, then the friendly amendment becomes the motion. If they reject it, then the person wishing to make the friendly amendment can formally move to amend. There can be up to 3 motions on the floor at the same time, and the vote will always proceed in reverse order, beginning with the last motion made. So that would be, in the example above, if somebody made a substitute motion, the CB would vote on that first, then the motion to amend, then the basic motion. Next slide. There are other types of motions. I think these can just be reviewed in your own time. We talked earlier about a motion to table, and that's when you just decide you want to discuss something at the next regularly scheduled meeting. And yeah, also Rosenberg's rules does say you need a motion to adjourn and to recess. We haven't been doing that under Robert's rules. So that's something maybe we should also implement, is do a roll call vote for those. And then present and voting, which we talked about, those present and voting are counted in terms of determining whether a motion passes. Next slide.
Motions to adjourn be oral? Does it have to be an actual vote count?
Sorry, could you say that closer to the microphone?
Motions to adjourn, can we just say aye and then be done, or do we have to actually count everybody's vote to adjourn?
Well, it's kind of funny because Rosenberg's Rules of Order only requires everybody could say aye and nay at the same time, but because of the Bagley-Keene requirements for teleconference, we have to do a roll call for all motions. So it does seem like overkill for motions to recess and to adjourn, but to be strictly compliant with Bagley-Keene, we would do a roll call for those too.
Thank you.
Yeah. So courtesy and decorum covered by Rosenberg's rules. The best practice is for one speaker to have the floor and for each speaker to be recognized by the chair before proceeding to speak. The chair should ensure the discussion focuses on the item at hand, and interruptions of a speaker should generally be limited. There's a couple of exceptions to that. One is point of privilege. That's like if there's a disruption, and somebody can't hear or something like that, they can say point of privilege and let the speaker know that they're not able to hear them. There's point of order and some other ones, but I don't think these are that likely to come up. You can review them more closely, I think, in your own time. Next slide. Public input. In addition to following the procedures for motions that we just covered, with respect to each agenda item, to ensure a maximum public participation and input, the chair should tell the body what the body will be doing. The chair should tell the public what the body will be doing, keep the public informed while the body is doing it, and when the body is acted, tell the public what the body did. And that just helps to ensure that there's clarity. And I think that's especially important with these hybrid meetings where there's some people remote and some in person. Next slide. In addition to adopting Rosenberg's rules of order, the board also made some changes to its policy manual on public comment. And those changes have already been adopted, as you could tell, as Paul covered earlier. The policy statement behind it is basically that, you know, the board and all of its sub-entities encourage a wide range of viewpoints and diversity in public comment. And these rules are designed to protect, you know, the public's right to participate essentially in the CBE's business. Next slide. Written public comments can still be submitted in advance of the meeting, and now they need only be submitted up to 24 hours in advance in order to ensure that the CBE is going to be sent the comments before the meeting. Before, we had asked a few days before, so before the meeting they be submitted. So now we will make sure that the CBE receives everything that staff gets up to 24 hours before. Anything that's received 24 hours or less or during the meeting or after the meeting will still get transmitted to the CBE. It's just that we're not going to guarantee that you get it before the meeting. Essentially, we let the public know that so that they can plan accordingly. Next slide.
Well, Caroline?
Yes?
Go back, Tyler. So I just want to point out that we've made the administrative decision. While the policy says that documents submitted less than 24 hours prior may not be provided to us prior to the meeting, we've decided, and it's reflected in the way I described it this morning, that we're simply not going to attempt to provide those documents. We're going to wait. You know, the staff half the time is, well, for these meetings at least in person, is traveling, and they have a lot of other things to do to get ready for a meeting. So basically, we're saying that's a cutoff rather than a warning that it may or may not get to us. It's a difference. I don't know if you noticed that, but I think we're allowed to do that within the context of the policy.
Yes, I agree. And thank you for pointing that out.
And also, I talked to Amy and Devin yesterday, and they agreed that they will, as public comments come in, especially if they come in, you know, like 5 days or at the start of a week, they will not wait until 24 hours before the meeting to send them to us. They'll package them every day or so and send out the ones they have by then to us. So we have more time to review them, and we're not stuck reviewing a whole bunch of comments in less than 24 hours time when we may be traveling as well.
Right. Yeah. Good point. And yes, I think that as the earlier the better is always true, but this is sort of the formal adoption of the 24-hour policy. And yes, what you said is fine. So anything submitted with less than 24 hours notice, the CBE will not be getting prior to the meeting. So the public should be aware of that. Okay, next slide. For oral public comment, members of the public are encouraged to sign up to speak in advance. And if they do sign up in advance, they will be called in the order that they sign up. Members of the public attending remotely can also raise their hand and ask to be called on, and they will be called on in the order that their hands appear. The chair will set a time per speaker not less than 2 minutes per speaker. And I know that, Paul, you wanted to talk about perhaps changing that time, but the time limit must be the same for all speakers on a particular item. And if many speakers wish to comment on one item, the chair may take general public comments at the start of the meeting and then take public comment on a specific agenda item when that item is called. So like for the example of the school. And spokespersons for groups of people are encouraged, but they're not allowed to cede their time to each other. So if a spokesperson decides to speak on behalf of a group, they're going to get the same amount of time as each individual speaker. Did you want to talk about the time limit, Paul?
Yeah, I think even the Board of Trustees, last time at their last meeting, they set a 3-minute limit, and I'm thinking that's reasonable. It's still way too short to make much of a point, and that's why I think people should seriously consider making written comments. but 3 is better than 2. And I know this from experience because I was making some comments to the board the last meeting in my individual capacity. And I spent a lot of time, repeating the words and timing them because I was afraid I was going to only have 2 minutes, and it was a luxury to have 3, but I thought that was useful. So does anyone disagree with settling on 3? If we did find a situation where we had like a ton of people wanting to comment, we could always take it down to 2, but 3 as a default seems reasonable to me, and I'm seeing nods around the table. Thanks. And let me see if there was another. Oh, I'm in the wrong place. I'll come back to it, Carolina, if I had another question.
Okay. And I would just say, I think the policy does allow that you change that, like depending on the meeting. So it's always got to be at least 2 minutes, but you could do 2 for one meeting, 3 for another. I think the important thing is just to give everyone that day the same amount of time to speak. So next slide, please. The chair has the discretion to allow members of the public to speak following closure of the public comment period. As was true before, it's not guaranteed that all who wish to speak will have the opportunity to do so if the committee runs out of time. The time allotted for public comment will vary according to the number of requests, so that's what we were just talking about. But generally, after 2 hours of public comment, inclusive of a 10-minute break, or up to the first 100 speakers, whichever comes first, the chair may declare the public comment session closed. Organizational entities who will be directly impacted by an action, such as a law school, will receive additional time to speak. However, time limits and limits on the number of speakers may be imposed, and they will be heard at the time their agenda item is called. They have to make arrangements not less than 72 hours in advance to address the body. Next slide.
How are we going to apply this to the exam subcommittee meeting considering TA appeals? I presume we won't face a situation where we have 2 hours worth of comments, but if we did, that would really cause trouble, I would think, with schedules.
Yeah, so a few members of the board raised similar concerns about like the board subcommittee and how they would manage that. I don't think there was a definitive answer on how to manage that. I think, why don't we see how things go? And then if there's like a huge volume of people showing up to comment at an hour-long subcommittee meeting that interferes with the subcommittee's ability to do their business in a reasonable time, we can kind of maybe seek some guidance from the board on what to do in that situation. That's what I was thinking anyway, because I don't think it's going to become a huge issue, but there isn't a clear answer on how to handle it yet.
It's more likely to for them than us.
Right. And they did, at least one of their members was talking about how, they tend to do subcommittee meetings prior to their big meeting. They don't want people coming and necessarily repeating the same comment at every single meeting because it takes up extra time and it's just kind of duplicative. So I don't know, we may see some kind of revised guidelines around this. We don't know exactly. I think it's going to take some adjusting and tweaking while we all, learn the new policy. So reasonable accommodation requests are to be submitted 3 business days in advance of the meeting. And this one's important. Public speakers who require an interpreter shall be given twice the time limit for other speakers. So if we decide on 2 minutes, they get 4. If we decide on 3, they get 6. And the granting of additional time for speakers who require other accommodations is at the chair's discretion, but must be sufficient to afford the speaker equal access. So I would say if somebody indicates that they need additional time as an accommodation, and again, they have to let us know in advance, they should be given probably just the same double time as the interpreter example. Okay, next slide. There's also additions that are to the board policy manual that relate to maintaining decorum at meetings. I don't know if the CBE has had as much of an issue with this as the board, but essentially members of the public who engage in disruptive conduct, and that's sort of a very specific type of conduct that is conduct that disrupts, disturbs, or otherwise impedes the orderly conduct of the meeting shall, at the discretion of the chair, be barred from further audience before the body at the meeting. I think this is like a very extreme situation that's very unlikely to happen, but this has become part of the board's policy. And so if it does happen, we need to make sure we're following policy on that. The board also, oh, go ahead.
Comment. This morning I read the anti-discrimination policy, kind of proactively, but without any hint that we really had an issue. So do you think we should only need to read that if we are facing an actual problem situation?
So I would, I'm glad you bring it up. I would distinguish between, I think there's like two things that could happen that this policy gets at. One is like disruptive conduct, where a speaker is making it impossible for the committee to do its business. And it's just, that person needs to be barred from further audience. That's going to be very unlikely to happen. The second category is somebody gets up and says something horrendous, discriminatory, harassing, terrible, but not necessarily what the law would consider disruptive, and freedom of speech may protect. In that case, the chair in his discretion can read the State Bar's anti-discrimination and anti-harassment policy into the record and then take the following steps. Tyler, would you go to the next slide? Actually, this is the State Bar's anti-discrimination, anti-harassment policy that would be read into the record.
Yeah, it doesn't seem particularly applicable to what we're doing. It's more about other situations relating to employees and vendors. I wonder if there's another policy that's more appropriate, but I'll leave that as just homework.
Okay. Yeah, I mean, this does, while it doesn't expressly state, that there's a zero tolerance policy against discrimination, harassment of our CBE members, it certainly includes staff. And we would read it to include our officers also. But anyway, next slide. So after reading the policy into the record, the chair could state that the comments in violation of the State Bar's anti-discrimination and anti-harassment policy are not condoned, welcome, or appropriate, and they interfere with the ability of those present to listen and understand. The State Bar can state that any State Bar employee who is offended or otherwise does not wish to attend due to the remarks is excused from attendance at the meeting during the remarks. The speaker's time will be held during the chair's admonishment, and the speaker will receive their full allotment of time unless their conduct becomes disruptive. And the speaker will be allowed to continue after the admonishment, and the chair may call a recess to allow staff or other members to leave or provide de-escalation. Again, I mean, I don't think that in my time, at least supporting the committee, I don't think that anything like this has come up. So we've been lucky in that way. But if it does come up, this is a procedure to follow. Next slide. There's also some changes to the policy manual about not being allowed to have signs that obstruct the view. Again, this may be something that the board has experienced, but I don't know that the CBE's ever had an issue with this. The policy also allows a waiver of the rules pertaining to meeting decorum in the event of emergency, but the emergency has to be one that meets the criteria of the Bagley-Keene Act. And then comments and materials received during public comment become part of the public record is the last change. Next slide. I think that's it. Yeah, that's it. Any questions?
As far as making comments being public documents, we had one of our public comments, I think, as an aside, indicated that there was no way to find those comments for the public. Question of staff: are we thinking about making those available via the web, or are you happy just having to gather them every time somebody makes a Public Records Act request for those comments?
The purposes of the new rules is to standardize from one sub-entity to the next. So I think we'll have to bring this back to the coordinator of all of our sub-entities to figure out how we can do that.
Yeah, I mean, I just asked them. Because I did stumble upon a public comment archive on the website, but what it turned out to be was just the announcements of various rule proposals that were out for public comment. And even that site did not include the comments that were returned regarding them. I don't know, in the name of transparency, it seems like that might be worth doing, although it may be the cost of actually doing it is more than the cost of responding to the few Public Records Act requests that you receive. I don't know, it's just a question. I'll tee it up for later.
Admittedly, like, I don't know all the policy considerations that went into that particular change, but I could do some research about it. I mean, I'd have some concerns about posting everything we receive as public comment, just like as a blanket rule. I think saying that it becomes part of the public record is helpful so that people know that we're a public entity subject to CPRA. So like what they submit to a public entity could become public. But other than that, I don't think I would support like a blanket rule where we post everything for different reasons, but.
Okay, I can understand that.
Yeah.
Larry, did you have a question?
Yes. In a nutshell, what are the key differences between Rosenberg and Robert?
I would say that taking the motion before discussion is something that sticks out to me as being as being pretty different. Also some of it's more clear, but it's also more formal, like taking motions to adjourn and motions to recess. And then also the chair's participation is at least a change from how we viewed Roberts to now. I think it's going to give a lot of clarity though to like the way meeting business is conducted, hopefully. And it's going to provide the committee with a lot of examples. So like if they want to make a certain type of motion, they have a reference point for doing that. You know, I think as with Roberts, it's important to remember this is a guide. We're not like it's not the same as like complying with Bagley-Keene, right? Like it doesn't carry with it the legal consequences like for failing to get it right. But it does provide like a helpful framework for the committee to do meeting business, which sometimes is daunting, especially for new members, like, oh, how, you know, for those who haven't served on committees in the past, and we have a lot of experienced committee members. But you know, it's just a nice roadmap for how the meetings are supposed to go. I find it pretty formal, but I think, you know, I'll get used to that too.
Larry, in case it's helpful, the board did discuss this at their meeting. And one thing I won't take credit for saying, Leah said it, is that the Robert Rules of Order are 2 inches thick and 700 plus pages, and Rosenberg's rules are 10. And so part of the reason for the switch is to ensure public access to our meetings, and so that kind of the bureaucratic criticism that Roberts often received, we're hoping that their new set of rules helps, you know, make public access greater at our meetings.
Okay. Next was a presentation about the budget. And I want to say in advance, I've been hopeful that we would start to receive more information about the budget as we used to in my early days on the committee, and I'm glad to see that staff is indulging us now. Thank you.
Great. Thank you, Paul. So as Paul's noted, I'm going to provide a highlight of the status of the budget. And so, you know, the reason for this is because, as you will see, the status of the budget is, it needs fairly significant adjustments. And so we believe that the board would benefit from the CBE's input and in their views prior to taking action. So that's why it's here today. So also it's important to note that today's a high overview of the budget, the status of the budget, but a proposed budget plan is going to come to the committee in January for feedback to be provided to the board for consideration. So overall, the Office of Admissions commenced 2020 with a structural deficit budget. Essentially, our expenditures outweigh our revenue, resulting on a heavy reliance on our reserves. And I'm going to get into the numbers in the next screen, but before we get there, I wanted to note that while the budget has experienced a steady reduction in revenue since 2008, the budget took a much sharper hit, which you'll see this year, and that's primarily due to the return to the in-person exam administration. We estimate that we're going to need nearly half of our reserves to complete this fiscal year. So years without fee increases and increasing costs have resulted in the significant structural deficit. So State Bar began assessing the actual cost of operations in each of our services. So that includes the bar exam, the first year law student exam, moral character, all of our NJP categories. So looking at registered in-house counsel, registered legal aid attorney, FLCs, registered military spouse attorneys, law school accreditation and inspection fees, PTLS, the law office study program, OSAC, even the PLL. And the idea was to compare our revenue to the fees collected for each of these programs. And essentially, the cost to carry out the work that to process these services, such as administering the exam and to oversee the law schools, is currently outweighing the fees that we're collecting for the programs. And so there are some factors that we need to take note of that have impacted the budget. And this includes things like that happened around the pandemic. This definitely had an impact in the budget, on our budget in many ways. First, we allowed applicants to withdraw from the exam, for example, in October 2020 and throughout 2021. Refunds were granted when applicants expressed concern about the remote technology or even having to take an exam during the pandemic. And this impacted the budget in the sense that staff planned for a larger number of applicants than who ended up coming to the exam. There was another factor that impacted us, and that was the remote modality. That remote modality offset the costs for the exam. It helped with cost savings and planning, but it's currently not a viable option because we do not have a remote MBE available to us. So bar examination fees this year were projected to be $2 million lower than 2021. And it had to do with the continuing decline in the number of test takers, something that I consistently highlight when I present on the key indicators here at CBE meetings. But essentially, we have a steady decline of exam takers for both the first year law student exam and for the bar exam. Also this year, we had a refund issue, or maybe last year, excuse me. So the refund issue related to the technology challenges experienced during the July 2021 exam impacted both the 2021 and the 2022 budget. Also, we had an additional refund that was granted to applicants who had health concerns over the return of an in-person exam format in 2022. So while the significant budget deficit in 2022 can be absorbed by our healthy reserve, it's just not sustainable on a long-term basis. So the areas that have the most significant impact on the budget include the first year law student exam, the bar exam, and moral character services. Just as a sidebar, an example, in this year, the cost for administering the bar exam is approximately $16.2 million when you account for all expenditures, which is something that we have not brought to this committee in the past. This includes staff time, consultants, like the TA consultants, psychometric analysis, graders, contract facilities, printing the books, developing the exam, travel to the site, and so on. And this year, we also only collected $11.2 million in exam fees, and that includes the first year law student exam fees. So just to give you some perspective, we're definitely not collecting. There's at least a $5 million difference between what we're collecting and what it's costing us to run that exam. All right, so Tyler, you're at our next screen, which is not a problem. So let's jump into the numbers. So let's go back here. So these are actual revenue, expenses, and reserve balances. as you can see here, we're going from 2018 to 2022. We're looking at all revenue. So in those categories, for example, in 2018, our revenue was $23.6 million. And as you go down through 2022, you can see that has dropped to about $16.9 million. One thing to note is that these are actuals as of October. So we still have November and December that need to be reported in here. So these are actuals as of October. The next broad category of expenses, as you can see here, our expenses in 2018 were $20.2 million, and in 2022, we're at $21.7 million. Again, the caveat being that we have not finished our fiscal year, so these numbers might fluctuate. What will not fluctuate here is, for example, exam fees. So we are not collecting exam fees for the past exams. The exam fees right now are for upcoming exams. In the lower rows here is our surplus and deficit actuals. So you could see anything in a parentheses is our surplus. In 2018, our surplus was $3.38 million. That declined. We had $267,000 in 2019. And as you go down, you can see in 2022, we're at a deficit of $4.8 million. And the last line here is the last row in this table is our reserve balance. So in 2018, we had an $8.1 million reserve balance. With the addition, for example, of our surplus in 2019, that went up to $8.4 million. In 2020, we had a surplus. Again, that was the year also that we moved to remote technology, and a lot of our expenses, such as travel, had stopped. So did our PowerPoint. So here we go. Is Joe here? Oh, yeah. Joe, do you know why?
That's probably from Tyler's end.
Okay. All right, we're back. So we ended 2020 with a $10.5 million reserve balance. We had added $82,000 in 2021, ended that year with a 10.6. And where we are now is we are forecasting, this says $4.8 million, but I think we're forecasting a little more than that, perhaps $5.1 million. And this is where I had noted earlier that we're using at least half of our reserve balance. So some things to highlight here is, as I mentioned earlier, our costs went down when we had remote exams. The last time that we raised fees in the Office of Admissions for all our applications was in 2014. It was voted in by the CBE and implemented over a 2-year period in 2015 and 16. A portion of the deficit that's reflected in here is one-time nature, and I've already highlighted those previously, such as the refunds and the credits from the ExamSoft issues. Also, there are systematic factors that are contributing to this, and that includes the decrease in the number of applicants and also the return to in-person exam administration. So I mentioned that we've conducted an analysis of what this deficit is looking like, and this is our plan at the moment. We're going to continue to closely monitor the 2022 fiscal year end. We want to reduce as much cost as possible, and some of this has started, and we've brought this here, such as limiting travel and in-person events. We want to also explore other revenue sources that are available to the Office of Admissions. We are 100% dependent on our fees. We do not access or use any general funds. We need to also develop a fee increase plan that balances the financial strain between law student and attorney applicants as that gets developed. We need to continue to also explore the possibility of moving to a remote exam. We've attempted to work with the NCBE on the possibility of a remote exam, and also started exploring the development of our own multiple choice questions. We've also embarked, and you heard earlier about the use of Prometric, but researching remote testing options that facilitate a good user experience while maintaining the high level of security that are required for high stakes exams. As part of this initiative also of tackling and looking at our fee increases, we're going to bring a proposal to the CBE, as I suggested earlier, in January before it goes to the board, so that you provide input on those recommendations. So with that, this is a lot, and I just want to open it up to see if anybody has any questions or comments.
Amy, that's a wonderful presentation. So I have a question. The number of law students, has that sustained, increased, decreased over the last 4 to 5 years?
You mean law students applying for the exams? Law students.
Yeah, I'm just trying to figure out how many law students, and then comparative to how many law students are applying for the exam.
I did not bring any statistics on the number of law students, but I can do that before our next meeting.
Amy,
Yes.
oh, go ahead, Larry.
What about the number of, but there has been a decline in the number of people applying for the exam, correct?
Correct.
And is that viewed as sort of like a long-term and national trend?
Correct. Yes, it is.
So in other words, this is really interesting. This is like the classic, like sort of like newspapers, okay? You've got you've got a shrinking market, right?
Yes, I can't tell you how that looks on a national level, but yes, in California, it is a shrinking customer
Yeah,
pool.
so that means that the steps that we have to take to have a balanced budget, either, making cuts and increasing fees, I guess, that's really the only area we can, has to be a long-term approach. Can't just be like, oh, this year we're having a problem, so we'll deal with it this year. It's actually got to be a long-term approach, because, we've got basically a shrinking market, right?
Correct.
That's depressing.
It is.
Okay.
All right, Alex, I think you had a question.
I'll let David go
Okay.
first.
We lost our.
Oh, yeah. Tyler, do you mind putting up the budget one more time, please? Uh-oh.
2021, 1,254,623. 2022, 4.5 million. That's on services. What was that increase there? That's a significant jump compared to a lot of these others. I was just curious, what type of services? Building or no?
Let me get that for you right now. Services include professional services, outside legal services, printing, the delivery, document destruction, banking fees, fingerprinting, and other small categories. For example, witness fees, state bar hearing fees, equipment rental. But when I look at that jump, the significant portion of that no, services. Is professional services between, and the professional services that are reflected in here was our using the PSI vendor, which we're not using any longer. That created a big, there was a big increase in the professional service need resulting from that vendor. Remember, this is a vendor that we used to do the proctor recruitment in February and July of 2022, as well as some of the site procurement. And based on performance, we're not using that organization this year. I'm sorry, in 2023.
Ms. Jane, I'm sorry. Amber mentioned another group, premix or pre-matrix?
Prometric. It's Audrey. Prometric.
Prometrics.
No, this was all about the bar exam. So Prometric we used for the first year.
Instead, what we did is we brought that service in-house. So we are going to take it on with our state bar staff and a consultant, one consultant.
And Amy, I'd like to mention also that one of the other fees we had that, although not as large as, say, the PSI part of it, we did have to pay for a vendor who came in February to help us do clearing of people, the applicants for vaccinations and negative COVID tests. So that was an extra cost that we no longer are incurring because we're not doing the same process any longer.
Dolores?
Just a quick question, comment, to follow up on Larry's comments. So if we're looking at a long-term projection of what's going to happen, the efforts to reduce the number of people who have to take the bar exam through various alternative methods of licensure is also going to have an impact on the revenues coming in to this department. And it seems to me that the costs of administering those new programs is going to be an additional drain on a decreasing budget.
You know, Dolores, depending on how the program's designed, that doesn't have to be the case. I think we're seeing some of that play out now. If you recall, the PLL application was very small. I think it costs $75 to apply. If you were IOLTA grant funded, I think that was a bigger reduction in that cost. I think you got, it was something like maybe $25 or $50. And so if we moved into this model of a bar exam alternative pathway, we would have to consider that in the cost of the application in order to compensate for that. I mean, that would be one remedy, is to address that concern, that a non-exam pathway would not equal revenue. I think we would have to consider how much that application process should cost.
Larry?
So to follow up on that, so in other words, we might increase the cost of the non-exam, correct?
Correct.
Yeah, and do we make, quote, make money on when someone takes the bar exam, or do we, quote, lose money when someone takes it?
Oh, we're losing money now.
You lose now per, if you broke it down per, yeah. So it almost sounds like we have to really thoroughly reevaluate the whole business model.
Correct.
Wow.
Yeah, and when you think about it.
That's like profound, okay? Because that's going to have an impact on everything we do.
Yeah, it's a big policy question. When you come back, Ashley, did you have a question? I'll let you go first. And then
Yes,
Alex.
I was going to say, do you
No,
want
go ahead, Ash.
Okay. Okay. I was going to say that one of the things that we noticed from, at least on a very small, my law school level, was that the admissions dropped pretty aggressively during COVID because there was less value in going to school remotely. So I presume we're going to see that drop as well in the next year to two of the bar. But then I assume possible that there would also be another surge. I think there was a surge in law school admissions in, I think it was like the early 2000s, that kind of buoyed the system. And I don't know if that's something that we can prepare for or look at or study before it happens to accommodate for the loss that we're going to likely see for the next few years.
And the recessions can also, and I think we're looking at one, that might also increase, if I recall correctly. Alex?
Great, thanks. Just made me, thanks for providing the numbers, because it made me think also, like, at least in the graduate business school sort of arena, where just growing the top line, like offering some other programming services, online programs. I know may not necessarily like be apples to apples here, but you know, if we're operating like sort of like trying to cut down on expenses and things, that may obviously not be the silver bullet that solves everything, but just trying to grow that top line. And we don't necessarily need to get into the weeds, but like, you know, the grants areas or other revenues that are up there might be another area just to kind of explore, like growing that top line. Because if it's a shrinking market, again, talking from the business school case, they were just like, hey, we got to start looking at other ways to grow that top line.
So I think there's some big policy issues here. Let me just highlight a couple that are in the back of my mind that you can have in your mind when you're bringing the presentation back in January. One is, should these various programs fully fund themselves, or do we want to subsidize them? For instance, keeping there in one of the statutes that talks about setting fees for the bar exam, it talks about trying to make it affordable for people of limited means. Where we are now, we don't really know how much we're subsidizing it, and we don't know where we're subsidizing it from. I guess it's really the surplus is what's subsidizing things at this point. The reserve. And philosophically, where I come from is everything should pay for itself. Kind of a Chicago School of Economics guy, where we let the market allocate things. So for instance, if the price of becoming a lawyer becomes relatively higher than other careers, maybe fewer people want to become lawyers, and that's. But we're telling people what it actually costs. Every time we try to subsidize, we artificially affect markets. I mean, that's just my basic philosophical bent. But I think at a minimum, we need to know which programs are carrying their weight. I fear that we will hear that it is none of them. And so where's the extra money going to come from? Because, am I wrong? The admissions fund is a closed fund, and we don't get money from elsewhere. We have the grants you got for that one study, but if we don't bring in the money, we can't really expend it.
Correct.
And you'll see for instance, in the letter from the bar associations about the BRC, they're asking the question, why are you guys thinking about all these new programs when you're seriously in the hole in the ones you have? And it should be a factor, I think, in the decisions we make about which programs to pursue, whether we can afford them, and at the expense of which other programs. So that's what I'll be looking at when you come back next time. Bethany?
I wanted to know, or I guess this is a discussion point for policy or research later, but I know that the cost for students that receive accommodations is like significantly higher than non-accommodated students. And so it's my understanding that a lot of that is related to the expenses relating to the hotels, having to get them their private rooms and so many extra days. And so I was wondering what kind of research had been done on alternatives, because it just seems that maybe that is one way also, that if we have to provide accommodations, obviously, but if we can find a more cost-effective manner to do so, that might also assist in some of these budgetary issues that we're discussing. And then I had a second point that I forgot now.
We'll come back to you. Larry?
Yeah, I just wanted to, again, re-emphasize my belief that, it's sort of like a bifurcated process here. There are things short-term that we look at, like, the cost of accommodations or et cetera, but I think we really have to think about the long-term, like demographics. For example, California's not growing that much anymore, which means student populations. You've read all the stories about the primary and secondary schools, how they're losing, their populations are declining because there just aren't as many kids. So that's a long-term challenge to our business model. We're designed for, this boom state, tons of people, rapid growth, lots of stuff going on, and that's not the future. So I just think it's important to look at that.
Okay, thank you, that's helpful.
Bethany, did it come back?
So this is relating to, Amy had brought up remote.
You were working.
Regarding the remote exam as a possible way to, work on decreasing costs in the future. And I'm wondering about that also, because it seems like the remote exams are just as costly, if not maybe more than when we do them in person, because of the increased cost regarding technology and getting people to manage that and implement that technology. And so I'm asking, like, is that true? Or, is the remote testing actually could be cheaper than the in-person testing?
It could be cheaper, but there are contributing factors to that. So, that we have some accommodations that are, aside from testing accommodations, we have handwriters that need to test in person. So there's always going to be a need for us to get testing facilities, whether that's hotels or convention centers. So in the remote exam, we had definitely a reduction in the need for those, right? So we only had a very small number, I wouldn't say very small number, but a substantially lower number of people that needed the in-person aspect. So that's a big cost savings to us. But also the ability for us to adapt, right? I mean, so one of the things that happened is during the remote exams, we needed to also maintain safety distances between each applicant. So we had almost every single, or I think we did, every single applicant that came in person had their own room for fear of ensuring that people were, we held public safety standards. And so sometimes it's hard for us to assess how much of that factored into the cost, but even when you consider that, things were less expensive. The exam administration was less expensive because we needed less space, because we needed less proctors, and because of, mostly everybody was taking this exam in a remote setting. However, those were maybe the exams in 2021, but again, in July 2021, like you've highlighted, we had a disastrous event occur with our vendor, and that cost us money out of our pocket. So that I think we needed to, it cost us staffing. There were a lot of different implications, like staffing time aside from, and resources. So I think that, it could be something that we could explore, and that's why we went to Prometric. We're trying to look for another vendor that can provide, two things, like a really good user experience. That's what we're trying to take advantage of. That is something that allows a multitude of people to take the exam if they can't find the testing space at home, that it's provided through a facility, and people won't have to travel much. One of the things that was appealing to us with Prometric is that people could take it anywhere. Somebody actually took the exam and they happened to be in Canada, and we were able to accommodate that. But without, there were issues too. Audrey mentioned some of those during her update. So I think it's going to be a work in progress until we get to a point that we're comfortable. But in terms of the financial standing, yes, it's proven to be less expensive altogether.
So it sounds like when we were thinking about programs, new and old, we need to have more of an eye on the costs. This should be a factor that we consider, which hasn't been the case in the recent past. So any more questions about the budget? No? Okay, let me, it's probably time, we're not going to finish the agenda by 5, that's for sure. How do people feel about going to, say, 6? And then whatever we can't finish, we can carry over in the morning, well, after the morning's item. Does anybody have a problem with that? I'm not seeing anyone.
I have to leave at 4:30, so as long as you could have quorum, just wanted to make sure.
Okay, yeah, so you're out of here now, I guess. Okay. Are you going to be with us tomorrow? Yes, I will. Okay. Okay. Good. Well, that's the best we can do. I don't feel like we've wasted any time today, but we just, it's maybe proving the point that we're going to have to give ourselves more time for future meetings. So I know I would like a brief break. So let's take a no more than 5-minute break to get set up for our next sprint to the finish or the intermediate.
What time is the finish again?
We'll quit at 6. Does
Okay.
that work for you? Okay, we're back on. And I need to find my place. Okay, we are in examinations. So, and Alex Lawrence, did you want to lead the discussions? I'm happy to take the first one if you want, because I'm semi-tuned into that. So the first item is O200, and that's a discussion of the Blue Ribbon Commission on the future of the bar exam, recommendations and next steps. Alex Chan had to lead us. Esther Lynn, you're on the phone. Are you?
Devon's saying she just dropped off.
Okay, Esther dropped off, so in the interest of time, let's put a pin on this one and see if we can come back to it. So the next is, Alex, that's yours. I think you want to take it.
Okay, so this is the approval of the technical report on the June 2022 first-year law students examinations. I'm actually going to turn it over to Christina.
Thank you. This is a standard report that we get after the conclusion of each first-year exam. This is the report from the June 22nd first-year law students exam. A short overview of the format, the scaling formula used to determine the pass-fail status for applicants, and it has the pass rate for the exam. The pass rate is just under 1% lower than the previous June 2021 exam.
I'm sorry, are you done, Christina? Yes. Oh, okay. Great. Are there any questions, comments? Dolores?
I know I read it, but I don't remember. You said 1% lower, and what is that number?
Thank you, Dolores. The overall pass rate for this June 2022 was 19.6%. It was 20.7% just the year prior, June 21.
Okay, we have a motion on the screen. Does anybody want to make that motion?
Torres, so moved.
Moved Torres.
Bethany, I'll second.
Seconded by Bethany Peak. Please take the roll.
Dr. Bolton? Robert Brody?
Yes.
Dr. Cow?
Yes.
Alex Chan? Jim Efting? Kareem Gangora? Judge Guerrera?
Yes.
Dolores Heitzinger?
Yes.
Judge Herman?
Yes.
Larry Kaplan?
Yes.
Alex Lawrence?
Yes.
Esther Lynn? Bethany Peak?
Yes.
Ashley Silva Guzman?
Yes.
Vince Reyes?
Yes.
David Torres?
Yes.
Dr. Wilcoxon? And Paul Kramer?
Yes.
The motion passes.
Okay, thank
Paul,
you, Mr.
so I have a question. You said you want to put a pin into the BRC. Is that the first item? Is that we're going to be circling back to that or wait till the next meeting?
Well, I'm hoping not to have to wait because we already put it off in the last meeting, but we need Esther Lynn in order to be able to do it, I think.
Right, so probably tomorrow between, I don't know if Alex is also dialing in or tomorrow, but yeah, that's it, yeah, so we'll circle back to that tomorrow.
Right, or if she reconnects today and we have time, we can do it.
She's not. She just emailed me. She's not.
Okay, she had to go, so we'll try for tomorrow. Next is the Operations and Management Subcommittee, Ms. Peak.
I will pass it to Tammy to start.
But she will join me halfway through. Okay, so we have on the agenda today the June 22 first-year law students exam cost analysis. As was mentioned before, we are continuing to do an online format with this first-year exam, so that's the way we did it for the June exam. Due to not having the ability to have conference space in LA, we did end up having to use the Hilton Los Angeles Culver City in order to do the testing accommodations and extenuating circumstances. But we did use our State Bar of California offices in San Francisco for the Northern California side. For the June 22 first year exam, the cost for the exam was $92,400 for 260 applicants. This compares to June of 21, where it was $52,900 for 275 applicants. Not much of a drop there in our applicant count, but a little bit. And basically, we're just pointing out how some of the costs are not shown in here, such as the staff that work on the exams, various consultants, things that we are not able to put into this cost analysis at this time. The cost analysis previously reported for the June first year exam in 2021 did not include any facility costs, as the exam was able to be held in both State Bar offices at that time for the in-person portion. And again, like I mentioned, we had one off-site facility that we used in June due to the unavailability of conference space. The drop in applicants from June 21 to June 22 represented a 5.5% decrease. And the increase in overall cost for June 22 can be attributed to an increase per person fee for exam ID and exam monitor. That had gone up from what we had seen the year before. And like the June 21 exam, the remote exam eliminated the need for paid proctors, as examinees taking the exam in person were proctored by our regular staff. And at this point, I'll hand it over to Bethany, who will present some of the highlights for the analysis.
Okay, so just a few brief ones. So for this exam, the largest percentage of our costs were associated with the facility cost for the in-person exam, for the in-person applicants, as well as for the exam software and proctoring as well. There were no specific costs incurred for the proctoring because we did use the State Bar staff, like Tammy had mentioned. Let me see. There were 13 applicants that took the examination in person due to accommodation or an extenuating circumstance. And those 13 individuals comprised 5% of the total applicants, but accounted for 55% of the total exam costs. And then my last highlight I have for you is that for one applicant taking the exam remotely, the cost was $169 compared to $3,897 for the applicants that were taking them in person at an examination center. So right now, I'll open it up for questions from the committee, if anyone has any. If not, I'll entertain a motion. Larry.
In person for special accommodations, or just, regular run-of-the-mill in person?
So that was actually applicants with testing accommodations, as well as applicants who had extenuating circumstances. So that would include somebody who needed to write the exam. It could include somebody who didn't have a reliable space to test in at their own home. And so it's a small number that we accommodated for, but the cost to do it, for example, at the Hilton Hotel, is the same of what we would have done when we were doing it in person. And it's just that we had to take the amount of space we need, but it's a lower number we're accommodating that need to be in person.
So what is the cost of, somebody taking the exam in, the big room with 500 other people? Or we didn't have that this time?
We didn't have that this time. I'd have to go back and look at some of our previous cost analysis. But when we were doing the first year exam, say at the Pasadena Convention Center for laptop and writers in one big room, it was running in line with what we normally would do, which was probably somewhere around a couple $100 per applicant. Versus, of course, when we do the accommodation sites, they do tend to come with a higher cost.
Any other questions? All right, if not, I'll entertain a motion.
I'll second.
Second by Alex Lawrence.
Moved by Torres.
Do we have the motion on, can we get it on the screen?
Do you want me to read it?
No, you don't have to.
Okay.
Let's take the roll then, please.
Dr. Bolton? Robert Brody?
Yes.
That was a yes.
Yes.
Dr. Cow?
Yes.
Alex Chan? Jim Efting?
Yes.
Kareem Gangora? Judge Guerrera?
Yes.
Dolores Heisinger?
Yes.
Judge Herman?
Yes.
Larry Kaplan?
Yes.
Alex Lawrence?
Yes.
Esther Lynn? Beth? Ashley Silva Guzman?
Yes.
Vince Reyes?
Yes.
David Torres?
Yes.
Dr. Wilcoxon? And Paul Kramer?
Yes.
The motion passes.
I think you have one more.
I do. So we have the next one is the July 22 California Bar Exam cost analysis. This exam continued to be back into the traditional format of doing it in person. It was held across 15 test centers. Again, the costs are not able to accommodate for including staff time and various other things that we're not able to include at this time in the cost analysis. However, for the July 22 bar exam, the cost to administer this to 7,543 applicants was $4.5 million. And when you compare that to July of 21, for 7,930 applicants, it was $1.6 million. The change in the number of applicants from July 21 to July 22 was a 4.8% decrease, so not too much. And now I will hand it over to Bethany, who will cover the highlights.
So we briefly addressed some of this when we were discussing the admissions budget, but the increased costs that we saw in this July exam are largely related to costs related to, sorry, I lost my train of thought. One of the, what are the people called? Vendors that we used to help assist us acquire more proctors for the exam. I'm back on track, guys. And so that is, well, if you go to your attachment, you'll be able to see the line items for the specific costs listed out there for your reference. Let me see. We ended up receiving a credit back from one of our vendors, which was PSI, this entity I'm talking about that was acquiring proctors for us, because we had contracted for them to acquire about 1,400 proctors, but they only were able to give us 1,100, which resulted in us having proctor shortages, which is obviously what we were trying to avoid this year. And so they issued us a credit back of $428,700. Let me see. A few more other highlights. So for this examination of the July 2022, it cost approximately $229 to administer the exam for an in-person applicant at a standard testing center compared to $375 for applicants taking them at an accommodation center. Yep.
And I would just like to point out with regards to the cost per applicant, if you looked at the spreadsheet, normally, you would be used to seeing our testing accommodation test centers are upwards of $3,000 per applicant. But when you look at this Excel spreadsheet for July, the costs don't show that. And the reason why is because PSI, the way that we were billed with them is not breaking it down in detail by test center of how many proctors we had. We did still control 4 of the contracts for the July exam because we had already done those prior to PSI coming on board. So there was this separation, 4 sites, we had to take on everything. They did provide us proctors. The rest of the sites, they took on everything altogether. But the billing or the way that they billed us doesn't provide that breakdown in that detail by site. So we were not able to really accurately allocate the PSI costs across all test centers. So we just did it as one lump sum on the Excel spreadsheet. And so the numbers are skewed by test center, but the final number for the overall cost per applicant for the exam is accurate based on the total cost and the total number of applicants. So I just want to make sure I threw that out there in case somebody had seen that and was going to question it.
And on that note, we'll open it up for any questions from the committee about this report.
Okay, there's a motion on the screen.
So moved. I'll second. This is Robbie.
And who seconded?
Robbie.
Mr. Brody, please take the roll.
Dr. Bolton? Robert Brody?
Yes.
Dr. Cow?
Yes.
Alex Chan? Jim Efting? Kareem Gangora? Judge Guerrera?
Yes.
Dolores Heisinger? Judge Herman?
Yes.
Larry Kaplan?
Yes.
Alex Lawrence?
Yes.
Esther Lynn? Bethany Peak?
Yes.
Ashley Silva Guzman?
Yes.
Vince Reyes?
Yes.
David Torres? Dr. Wilcoxon? And Paul Kramer.
Yes.
The motion passes.
Okay, the next agenda item is 0402 on educational standards, administrative updates.
You or me? You?
It's fine. You may wish to rest on the report. Everything is in there.
I'm
It's
sorry, I'm
just-
having trouble hearing you.
Oh, sorry. I would suggest we rest on the report. Everything is in there.
Okay, and there's,
Including the planned departure of the Dean of St. Francis Law School, who happened to join us today. And they'll be having an interim dean while they fill the big shoes he leaves behind.
so you're saying goodbye to us? Okay. All right, so, and there was no motion required for that one, correct?
Correct.
Did anybody have any questions on this report, 0402? Okay, let's move then to moral character. We've already talked about some of this earlier. 0500, approval of revised procedures governing informal conferences and procedures regarding requests for administrative review. Ms. Heisinger?
Yes, thank you. So at the October meeting, the committee considered the revised procedures in connection with the rules for moral character. And we asked to revisit the procedures at this meeting. Several committee members expressed reservations specifically about suggested changes that only allowed applicants to appear for an in-person conference for good cause. Therefore, the proposed revisions were amended to allow the applicant to request an in-person conference at a scheduled date by the State Bar with at least one member of the panel. So the new paragraph G revision states, generally, applicants invited to participate in an informal conference will participate remotely. An applicant may request to attend the conference in person at a date scheduled by the State Bar with at least one member of the panel. So that is the revision to address the concerns of committee members.
And I just want to add, based on the discussion from earlier today, it sounded like there was some consideration of adding procedures for new members of the committee before they join the moral character subcommittee to the procedures regarding requests for administrative review. But I would actually suggest that that be a separate document, since this more so governs the process for the administrative review versus actually the orientation for the staff or the committee members. So that is something that we could work with Dolores and then maybe bring back at the next meeting. And the other part I wanted to bring up was based on, again, the discussion earlier is so for the procedures regarding the request for administrative review, paragraph E is the one that states that the chair of the moral character subcommittee will designate a panel of 2 members. So we could, if the committee so chooses, modify that to say at least 2. And so I just wanted to highlight that as well.
Well, yeah, you'd have to do more than that, I think, because if you're suggesting that the additional person then has a role in making the recommendation to the committee, I think that's not what we mean. We simply mean they're going to be there to observe. So we'd have to clarify that. Let me ask you though, I recall, I don't have it in front of me, but there was another provision in these that talked about who could attend. That was the informal conferences, but it was very specific that the attendees were limited to the delineated people. So should we not add the possibility of a member of the Committee of Bar Examiners who is simply sitting in as an observer? See what I mean?
Yes, and give me one moment, I'm pulling it up right now.
That change wouldn't be made today.
Since they're proposing we adopt them today, I would suggest we do that. That would then facilitate, it doesn't require that we be there. It simply, it eliminates our need to further modify these procedures on another day.
So that would mean adding, or a member of the Committee of Bar Examiners to H then of the procedures governing requests for informal conferences.
Yeah.
Oh, Paul, this is Robbie. Can you hear me?
Yes.
Yeah, I just want to make sure I understand. Even the designated CBE members don't attend the conferences.
No, we were talking though about as part of the orientation for new people, and frankly, even me, I've never actually done one of these. If I wanted to get involved, that they have an opportunity to see an informal conference in person, just to observe it, not even stick around for the deliberations, so that they're not tainted if the matter subsequently comes before us. But I think given this very strict rule about who can attend, I think we need to provide for that ability if that's part of our plan.
They'd still have to recuse from everything. So even if they don't participate in the deliberations, and I don't know, you'd want to make that clear in the rules so that the applicant didn't think that they could potentially sort of influence the committee's view, which would not give them like a neutral sort of, or, you know, a true shot at an appeal with the committee. I don't know. What if Tara is able to get like the Zoom what if Tara is able, at least for one, to Zoom record it and do that as part of that orientation, as opposed to have the committee member, although I suppose even that, it's supposed to be confidential, them viewing it later is sharing it, but
Yeah, it seems a little not right to have the observer have more information accessible than the very committee members that are going to decide. I think for now, unless we make a change at some future time,